All right. So today is plea deadline date. Jury trial?
Well, Judge, I filed a motion to withdraw on all three of his cases. We have
Could I see the
a
motion?
disagreement about representation.
Do you have the motions with you?
I have one of them, but I can get the other ones printed out.
I just need
He has one indicted case, Judge, and then two unindicted. And
So I have the 2025 PF 08119.
I've got 120.
And you have one, two,
And then
zero.
the indicted case is, my office didn't send it with me, but we filed it.
Okay. All right, the court is calling 2025 CR 007775, 2025 PF 08119, 2025 PF 2025 PF 08120. Could I have parties announced?
Robert Maurer for defendant.
And are you Mr. Dollar?
Yes.
All right. So your defense attorney has filed a motion to withdraw in each of your cause numbers. So when will you be able to hire an attorney?
I'm gonna need appointed,
No, that's not how it works.
represent myself, then,
Okay,
I mean, I don't, how does it not work that way? I'm asking for a court appointed attorney.
this is your court-appointed attorney.
He's withdrawn from my case.
Yeah, because I guess there's some sort of
Did you not give
conflict.
me an email?
I don't respond to emails, and those emails don't come to me. Those emails come to the court coordinator, and then that email is sent to the defense attorney and to the state. I don't review emails.
Well, I've tried to contact Mr. Maher's office several times over the past 6 months with no response. I cannot get an answer.
Judge, that is, I'd like to respond to that. Is complete nonsense.
I've got
He has been in my office. He has met with me. He has reviewed the evidence. I've discussed the case. I've discussed the offers. He's not happy with the offer, and I told him then we try it.
Yeah.
But just to speak frankly, and he probably put this in the email, it got to the point where he offered me extra money, somehow thinking that was going to change how I represented people. And I said, I've acquitted people on murder charges on appointed cases. And I'm offended by his attitude and his actions, and I don't want to represent him.
No, actually, you said shut the F up and hung up
I
in my
probably did,
face.
Judge.
Yes, you did.
Yeah, I'm
All right,
quite certain
so,
I did.
Mr. Maurer, state, do you have any objections? All right, Mr. Maurer, your motion to withdraw in all three cases will be granted. You'll need to retain counsel.
Thank you, Judge.
All right, Ms. Ferguson,
Yes, sir.
recall this in 30 days, and it's for the defendant to obtain an attorney.
Yes, Marie.
My bonds didn't have me fucked up.
No, I didn't.
They told me, yeah, you did, and you called my pre-trial officer and told them the same thing. Tried to get me locked up.
Good afternoon.
Good afternoon. All right, court is calling 2025 CR 009749, State versus Cullen Spencer O'Neill. Can I have parties annexed?
Magdalene Brown for the state.
Brian Kimbrough for Mr. O'Neill.
All right, and are you Mr. O'Neill?
Yes, ma'am.
All right, according to your plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison. The state is opposed to your applications. Have both parties had a chance to review the PSI report?
Yes, Judge.
Yes, Your Honor.
Any objections to the PSI report?
No, Judge.
No, Judge.
All right, state, you're opposed. Do you have any witnesses?
No witnesses, Judge.
Defense, any witnesses?
Yes, we have some witnesses. Your Honor.
All right, call your first witness.
Before I do, Your Honor, I have some letters that I wanted to present the court on his behalf, and I believe, and I did give a copy to the state, and I believe they were opposed to my doing so. So I wanted to give them an opportunity to speak to that.
All right, any objections to the court reviewing the letters?
Yes, Judge, I'm gonna oppose their hearsay. I can't cross-examine the witnesses on those statements, and I don't believe they're sworn statements either, so I'm gonna object to them.
Well, Your Honor, I've produced, these have nothing to do with the incident. They're only about the character and the information about the defendant. I think it's part of the court's duty.
So with regards to whether they're hearsay or not, the court needs to review it to see if it is hearsay. And then,
You can rule.
if the court determines it is hearsay, then the court can always disregard. All right, with regards to the state's objections to the court reviewing the letters that have been tendered by the defense. The court understands your objections. The court is going to overrule those objections. The court will take these into consideration in sentencing.
Would
All
you
right.
like to have a copy so they can review them?
Oh, I've reviewed it.
You-
Yes,
Okay.
I read very fast.
Very fast, thank you.
All right, call your first witness.
Your Honor, I would first call Tammy O'Neill. Yes.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right, you can lower your hand, state your name for the record.
Tammy Hollis O'Neill.
All right, counsel, you may proceed.
Thank you. Your Honor. And what is your relationship with Cullen?
Yes, I'm his mother.
And could you tell me a little bit, was Cullen raised in San Antonio?
He was raised in
Okay.
San Antonio, born in Japan, but came here shortly after that because his late father was in the military,
And how long was his father in the military?
24 years,
What branch was he in?
Air Force.
Are you also in the military?
No, sir, I'm not. I worked as a civil servant, but not now because I'm furloughed.
Because the government is
Yes,
shut down-
that is
currently
correct.
shut down.
That is correct.
For the Air Force?
I do work for the Department of Defense. That's correct. Air Force. Yes, at the Air Force Civil Engineers Center.
So Cullen's father passed away 7 years ago, correct?
Yes, sir.
And
2018.
how did that, from your perspective, and was Cullen living with you at the time?
Yes, sir, he was.
And how did this affect him? The death
Hugely,
of his father?
hugely. It affected all of the kids, right? My daughter as well, but I think it struck Cullen much harder, right? Because of that father figure that he had in his life. And also that father figure to hold him accountable.
And how many siblings and other members of the family did he grow up with?
Yes, he has a younger sister, who's not here to testify today, ma'am. One of the letters was from her. She's full-time in college and couldn't come. And then he has a stepsister as well.
And can you describe his upbringing, his childhood? Was it normal? Was it good?
Yes, sir. It was good. I would say it was good. He got everything he wanted, you know what I mean? One of those. And I did the best to raise him, with my husband and then as a single mom after my husband passed away.
Did Cullen go to school?
He did. He graduated. He's got a diploma.
Got a diploma. He had to get a GED, right?
Yes, he did.
Yes.
He
But
did.
He did.
He struggled a lot in school with ADHD and also so he has struggled with that throughout his life since he's been little, right? Hard to concentrate, anxiety, right?
And has he been employed, generally speaking, since he got out of high school?
Yes, sir, he has. He has.
Has he always sought employment?
Yes.
And to your knowledge, has Cullen ever been convicted of anything, any crimes in his
No,
life?
sir. No, sir. This is so outside of his character. And I have never witnessed this type of behavior in him.
Okay.
Which is why this is so shocking. I've had so many conversations with him and I think he regrets what happened, right? I feel like from his personality, this is just not something he typically would have done. And I feel like that it was a mistake. He just made a poor decision, a very poor decision.
And he's always lived at home, correct?
Yes, sir.
And so you've gotten to know his friends.
Yes, absolutely.
Okay. And would you say, based on your knowledge and your observation, are his friendships appropriate age-wise?
Yes, sir. I've never seen anyone under legal age at my house. That's another thing I think that my daughter wrote in her letter that even when I'm not there, she didn't witness that either as well. His relationships have always been with people of age, which is why this incident was so outside of his normal character.
And has he had friendships that were long-standing? In other words, friends that he's had for many years?
Oh, yes, yes. He has friends that he went to kindergarten with, right? And one is here today, actually, so.
Now, you know that we're here to ask the judge to place Cullen on community supervision
Yes,
for
sir.
adjudication.
Yes.
You think that he could succeed on community supervision?
Yes, sir, I do. I do. I very much do. I think that he needs that discipline, right? Of being able to check in continually. He's been on an ankle monitor for the last year and a half and has done that very successfully, right? To be able to check in and be accountable to that. I think that he can give back to society by working and doing other things while he was on probation versus if he was incarcerated.
And that's fine. Pass the witness.
All right, any questions?
No questions, Judge.
All right, thank you.
Thank you. I appreciate your consideration. Thank you.
And I would call, yes, I would call Deborah Higgins. Deborah Higgins.
All right, can you raise your right hand?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Deborah Higgins.
All right, counsel, you may proceed.
Thank you. And Ms. Higgins, you go by DJ, is that correct?
Correct.
Okay. What's your relationship with Cullen? How long have you known him?
I'm a family friend of approximately 14 years.
Do you remember how you first met the family?
I worked with Cullen's mom.
Was that in the Department of Defense
Yes.
area?
Yes.
Are you still working there?
No, sir, I retired July 25th this year.
And in the course of working with his mother, did you get to know Cullen a little bit?
Yes, I would go to their house for holidays and dinners and cookouts and whatnot.
What did you observe about Cullen during your period of knowing him?
He's a good kid. You know, he was raised well. I watched how him and his sister were raised. They were raised well. They did well.
Did you have occasion to see him with other young people?
I met one or two of his friends when we were all at the house. They're good kids.
And did you ever hear about anything that he might have done other than this incident that raised concerns for you?
No.
And you also work in pet safety or something?
Animal rescue. Yes.
Animal rescue.
Yes.
So you observed what happened today and you were
Yes.
familiar with it.
Yes.
So you do not condone bad behavior?
Absolutely not.
Okay,
Right is right and wrong is wrong.
you're hardcore on that.
Very.
Okay. And you know that what Cullen did was wrong.
Yes.
In spite of that, do you think that he could succeed on community supervision if the judge would give him that?
With structure, accountability and discipline and having to stay focused on that thing, yes, I do. I think he would do very well with that.
And do you think that would be a better outcome than sending him to prison?
I do.
Why is that?
There's prison structure and there's, I don't know the right legal term, but probation structure. And I think him being employed, being forced to do the right thing every single day in a more open environment would be more beneficial to him to grow as a young man.
Pass the witness.
Any questions?
No.
All right, thank you.
Thank you.
Call your next witness.
Yes. I would call Melissa Daly.
All right, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
I'm Melissa Daly.
All right, just keep your voice up so the court reporter can hear. Defense, you may proceed.
Thank you, Your Honor. Ms. Daly, you're acquainted with Cullen O'Neill, correct? How did you know Cullen O'Neill?
I've known Colin since he met my son practically in kindergarten. And all the groups of boys always played in the neighborhood. So I watched basically Colin grow up since kindergarten.
Okay.
And he's always showed the utmost respect and yes, ma'am. And when I had groceries, he'd be the first to come help me take them out of the car. I had him spend the night several times. And I treated him like a son of mine. So
Okay.
this is totally out of character.
Mhm.
So,
What is your son's name?
Daniel.
Daniel, and he is a friend and grew up with Cullen, correct?
Yes, sir.
Is Daniel here?
Yeah.
Daniel, okay. Now, would you, if you had had any issues with Cullen as far as his influence, would you have allowed Daniel to spend time with Cullen?
I hadn't had any issues with Colin.
Right,
so,
but if you had.
Oh, of course I would. But I have not seen, Colin's has always presented great character and integrity. And I thought when he was raised with his father hunting and having all the things that every boy would dream to have, was a bad dude. And since his dad passed, it was very heartbreaking. But he had a group of friends that supported him. So he wasn't like a loner child. He had lots of friends. And that helped him get through that horrible situation during his prime time in childhood.
And do you think that that he would be a good candidate for probation, community supervision?
Yes, I do.
You think he could succeed on that?
I absolutely do think he succeeds. He's has high integrity, and this is just outside his character. This incident.
Thank you. Pass away.
Any questions?
No.
All right, thank you so much. Call your next witness.
I'm gonna call Cullen, Your Honor. Cullen O'Neill.
Can you raise your right hand?
Sir.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help
Yes,
you
ma'am.
God? All right, you can lower your hand, state your name for the record.
Cullen O'Neill?
All right, defense, you may proceed.
Thank you. Cullen, you know why we're here?
Yes, I do. I made an egregious mistake one night. I had no sympathy for the situation I was in due to being under the influence of drugs and alcohol. And I made an honest young man mistake with my emotions and what I was trying to do. I made a horrible mistake. It's been haunting me. And I mean, I've had to deal with it for a year and a half that I've realized it and sat with it. And people have made fun of me. I've gone through it, but it's something that I know that it's not over because I made a mistake and I'm willing to take that on the chin. You know what I mean? You talk about football and LSU. I'm leaving it all on the field. You know what I mean? With what I'm trying to do to prove that I need a plea, but I made a mistake.
Okay. Now, the evening this happened, you had been using drugs, correct?
Yes, sir.
And you'd been drinking.
Yes, sir.
So you have an issue with drinking and with drugs.
Yes.
And you're willing to deal with that.
100%
Okay,
to get better.
to get better. Do you have an attraction to younger women?
No, ma'am. I mean, no, sir. I've never once ever in my life. I think it was just the influence I was in, the situation of not sleeping, being tired from work, just and my emotions, my feelings as a young man just overcame me. And I know that's horrible and I made a mistake for that.
Okay. Now, you did complete your GED, correct?
Yes, sir, I did.
Okay. And do you have plans and things that you want to achieve in your life?
Yes. So I was a month away from finishing college when this all happened. And I had been held back for a year and a half to even finish college. But what I was doing in college was being a gunsmith. I get with my situation now, I might need to find a different line of work. And what I've been doing as an iron worker and doing stuff outside and building buildings like Chick-fil-A's, Walmart's, and Chase Banks and stuff around the community the best I can.
Now, you were employed with an iron, what kind of a company was it? An iron?
It was an iron company. It was Hill Country Steel. We do all the main steel around all of San Antonio, Austin, and Dallas. We do every Walmart, every Chick-fil-A, every Chase Bank,
Okay.
every car wash. We provide the steel.
Well, did you start working with them when you were in high school?
Yes, right out of high school. one of the letters I gave was from the employer that I've known since right out of high school, and he helped me a lot. And he knew about my situation through house arrest and getting my job back.
Now, you're not currently working for him, right?
No, I stopped working for him because I wanted to deal with this and didn't want to interrupt their company for my mistakes.
And are you hoping to be able to get work again?
Yes, I actually have a job interview on Thursday for another steel company that was smaller that we used to provide steel with. So that's something I'm really looking forward to start doing and working.
Tell the judge why you think you could succeed on probation.
I did track, football, and baseball all throughout high school. And I work harder than most grown men that I know. And I know I messed up. And I don't want to do prison because that's just not something I know I will succeed in, unfortunately. But I know that doing the plea and being on a schedule, checking in and doing things like that will really help me a lot. Get my life back on track. I'm young. I made a horrible mistake for my age. And I know that I want to be able to recover from it and not be stuck.
Now, when this happened, understanding the situation, you do admit that you were told that the girl was 15.
Yes,
correct?
Yes,
And you also admit that when you were going to see her, it was because you were intending to have sex with her, right?
Yes, I admit to that. You know what I mean? I admit to the court to take my honesty because I made a mistake.
Yeah. But that's not something you have ever done.
Never thought about it, never once been around it. And I have a little sister. How could I do that to her?
Okay.
You know, like that's something that I really think about a lot and being a better image for her, especially with the situation I'm in. I want to get out of this and be better for her. And she was one of the main people that wrote a letter.
Okay. Pass the witness.
State.
A couple questions.
Yes, ma'am.
You talked to probation prior to this hearing, correct? The pre-sentencing report.
Yes, ma'am.
And when they asked you about the offense, you minimized it, correct?
I was nervous to what I said. I was very nervous on what needed to be said, and I wasn't sure what to say. I've never been in a situation like this, and I've never had the thoughts that I had.
But when you spoke to probation, you did minimize what you did in this offense, correct?
I wouldn't say minimize. I told my side the best that I felt that I could, but I did make mistakes. I did say things I wasn't supposed to, and we're here in this situation because of my mistakes.
Right. And the officer didn't force you or coerce you into this situation.
I mean, it was a sting operation.
Correct, but you willingly agreed to meet this person. They didn't force you to meet them,
Yes,
correct?
after like maybe 30, 45 minutes of time had passed since they had started talking to me, yes.
And you described in great detail and graphic language exactly what sex acts you wanted to perform on this 15-year-old. Is that correct?
Yes.
Pass the witness, Judge.
Any other questions?
No, Your
All right, any other witnesses?
Honor. No, Your Honor.
All right, court will hear brief argument. State.
Judge, I'll let defense go first.
Your Honor, Cullen O'Neill, in my opinion, is a perfect candidate for probation. He checks off the boxes, so to speak. He's 22 years old.
Okay, and not to interrupt your argument, counsel, but this,
Well,
no. This is what I wanted to address, but nobody addressed it. I don't know if anybody wants to address it. And it has to do with the cocaine that's mentioned in the PSI. And I don't know if you want to address part of
Well,
that with your,
yeah, I mean, I could ask him.
Okay.
If I could recall.
and I'm sorry about that. Yes, you could recall it.
Sure, sure. You had cocaine that night, correct?
Yes, it was for myself, yes.
And you were using cocaine.
Yes, I was.
And you were, as you earlier testified, you were using alcohol too.
Yes.
And you had and did this problem develop like years before?
It mainly developed a year or so before of just working hard and just trying to stay up and just trying to deal with college and deal with a full-time job. I didn't know how to overcome myself or talk to and that's just what led me down the rabbit hole right there. And I just messed up.
And you understand that when you when you got to the point what happened that night, you were showing, you had an alcohol and drug problem. right?
Yes, I
And you-
definitely did.
And you have it now. Correct?
I wouldn't say now. I have definitely resorted to staying off, being a lot better person just due to my probation with my ankle monitor. You know what I mean? Just in case for whatever reason they wanted to drug test me or whatever, God forbid that they would do. I mean, and I have a little sister and my mom, and I don't want to keep that image. I really don't. You know, that's why I really would like. I don't mind doing drug tests, drug classes, or probation or whatever.
All right, and I just asked that because I forgot to bring it up so that could be cleared up because it was in the PSI. So sorry for the interruption.
No, no,
Okay.
no, you're fine.
Are there any other questions?
No more questions.
All right, I'm sorry. You may
Okay.
proceed with your argument,
Okay,
counsel.
thank you. So, and, that charge was
Dismissed.
dismissed.
Yes.
Again, as I was saying, I think my main point is that Cullen is a very good candidate for probation. He has no criminal history. He is 22 years old. He has a very, very supportive family. He has friends that he's had since he was in kindergarten that are still his friends. I brought family members and I brought friends that have known him that are not related to him. All of them, including the letters that the court read from his employer and from other people that are friends that are not family. His sister did write a letter. All of them attesting to Cullen's character and their long history of knowing him. That isn't to say that what he did was not illegal and wrong. He should be punished for it. But he should, in my opinion, be punished in such a way that he is rehabilitated. This is a case where, to me, it cries out for rehabilitation, not for prison. Prison would be the opposite, in my opinion, of what should happen. Now, I know this is a crime that is extremely terrible, and there is a lot of outcry against this behavior. And I agree, it's fine. I'm not opposed to that. But in the appropriate circumstance, and I think this is one, a person that does this kind of crime can be rehabilitated and can go forward and contribute. And of all the people that I've represented for some time in the last couple of years, Cullen seems to me to be the best candidate for probation. And I'm hoping that the court will give him that opportunity. Whatever program, whatever monitoring the court feels appropriate, I'm asking the court to give him that chance.
All right, state.
Judge, I respectfully disagree with defense's view that this defendant is a great candidate for community supervision. This defendant has a pattern and throughout this case of hiding and minimizing his behavior. When he speaks with the undercover, instead of putting what he wants to do in a text message, he insists on talking. And he says those things over a voice message, so it's less traceable. He gets there, what happens, he gets arrested. He gets to this court, he pleads on this case to supposedly take responsibility. And when given that opportunity to take responsibility to the PSI officer, instead of just saying, I chose to go there that night, he says, well, she pushed me. The officer pushed me to do it. The undercover pushed me. He blames the undercover, doesn't take full accountability. And even today, he says, oh, well, the reason for that is I was scared. If his reaction to being scared, concerned, anxious, or nervous is to lie, to minimize, that is a terrible candidate for probation because he's going to keep doing it on probation. Judge, the descriptions in this report that the court has in the stipulations of what he specifically says, he's not just saying he wants to meet up and have sex with a 15-year-old. He uses graphic sexual language, graphic violent language to talk about not only physically, but sexually abusing a 15-year-old child, who he fully believes at that time is a 15-year-old child. I understand that this defendant is young. There may be some substance abuse issues. However, Judge, this is not the kind of person who I believe would be safe on our streets. I don't think he's a good candidate for probation, and I would worry about an actual child being harmed if he's let out. So I would respectfully ask the court to deny the applications for community supervision and sentence him under the plea agreement for 8 years.
All right. So, Mr. O'Neill, I want you to know that I heard everything from all of the witnesses. I reviewed the PSI. I've internalized everything. I've read the chat messages that was sent to someone you thought was 15.
I messed up.
Yeah.
I messed up, Judge.
All right. Oh, it's okay if he says something.
I mean, I'm upset about this, you know what I mean? Like, it's just my life, you know? And I mean, I just want to fix it the best way I can.
All right. And I want you to know I'm taking in consideration your age. And I do understand that sometimes people will do things, they're intoxicated, be it through drugs or alcohol. However, in reading the stipulations and in reading the PSI reports, there were so many times that you could have just pulled back.
I did not understand. You know what I mean? I really did. If I had a better understanding, I would have been honest, like I have been today.
No. I'm not even, here's the thing. This is what I understand. When probation officers are interviewing you for a PSI report, there are a lot of things going through your head, right? You don't want to say anything that could hurt you. Sometimes defense attorney, I was a defense attorney, and let me just tell you what I would tell my clients. I would tell them, for the love of all that's holy, just say, my attorney told me not to speak about it, right? And then sometimes I would have clients, I'm like, go ahead, tell them. So I will tell you what is in the PSI. I'm not holding that against you, because sometimes when people are faced with legal decisions, sometimes they get nervous. Sometimes you have a lot of voices in your head. What would my attorney say? I understand all of that. So I'm not holding that against you, that maybe you said something that could be considered you're not taking responsibility. So I want you to know that.
Yes, ma'am.
What I'm talking about is the offense. And it's like, there's so many points along the way that you could have stopped. Like, not drive over there,
Yes,
not go to the hotel,
I agree.
not go up to the hotel room.
I completely agree. And that's something that I've talked to myself and my mom and my family about, and my friends about, why I even did it. Because in no right state of mind ever have I ever thought that way or been in a situation like that. I crashed out, and I didn't know what sympathy was for the like the situation I was in. I really didn't. And I was young, I was sleep deprived, I was off drugs and alcohol, and I really did not mean to make that decision. And that's not who I am as a person. I've never lied to my mom or people about my situation. I've always been honest when they asked, especially how I got my job back. I had to sit there in front of a bunch of grown people and explain what happened.
Mhm.
You know what I mean? And that's something I can't be unhonest about it, because look how it looks on a piece of paper. You know, no matter what I said, no matter what I did, it's what's shown. And I mean, that's what's here today in front of us. Like, and I made a mistake, but I don't believe that I deserve prison, because I want to be rehabilitated. I know I can work through what the plea says. I know my punishment isn't over. It'll be at least 10 years that I'll have to deal with whatever the plea requires. And I know that.
All right, so this is what the court is going to do. The court is going to find you guilty. The court is going to order Chapter 62 compliance. There's a $3,000 fine, time and money to run concurrently. The court will sentence you to 3 years in the prison to give you credit for any time served. Did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over that, what that is, you'll need to speak to an attorney. Do you understand?
So 3 years?
Yes. But like,
Well, I have.
I'm sorry. You talk to him? Well,
Yes, here, but I have another thing I'd like to raise.
yes.
This is not a 3G officer. And
No,
so
I didn't-
Did the court retain jurisdiction?
I'll consider it. I'll tell you what, you can file whatever you want to file, and then the state, you can, make whatever arguments you
May I-
want to make, counsel.
Excuse me, may I hug my mom?
No, you'll have to talk to the deputies. They're in charge of security. Counsel, yes, you can file it and I'll consider it, and I will, once it's filed, if he decides to file it, then of course, the state, you'll have a chance to raise objections if I decide to do it. Okay, thank you.
Judge, may we be excused?
Yes.
Thank you.
All right. So why did it come to this?
Your Honor, it was just a messed up situation that night. I wish I could have made a different decision. My son was in the car with me. I was worried about his safety 100%. And on a minute that hasn't gone by since this has happened, that I wish I could have made a better decision that night.
Okay, I understand what you're saying, but I still don't understand how an argument on the road comes to a pulling of a weapon. I just don't understand that. And they're asking for a driver safety course. They're asking for a gun safety course. They're asking that you forfeit your Horseshoe Bay badge credentials. And they're saying that you flashed a badge and that you were no longer employed with them. So I'm just trying to figure out what conditions would be appropriate for you. This is why I asked these questions, because
I only
there's a lot listed.
used the old time to diffuse the situation. I thought it would help. That was it. There was no other reason behind it.
Why did you still have the badge?
It was given to me by my chief of police at the time as a memento, because that was my first job there. Before I went to Border Patrol.
So where do you work now?
I've left I left Border Patrol in 2016. I went back to construction. I'm a home inspector
Mhm.
for new homes. Till this happened, I was planning on going back to actually apply for ICE. That's null and void.
I mean, but here it says that you pulled out a handgun with a silencer attached to it and opened fire. Am I reading that incorrectly?
No, so Judge, he has a suppressor, and so his parents live near Kerrville.
Okay.
That's what the mother and father, they had gone out to her birthday celebration that night. He was going home with his son. And they have it's in a rural area, so they actually have kind of a setup where they do target practice. The suppressor has more to do with not making loud bangs. That's why he had, and it's legally owned. He's got the stamp for it. I have it in my file back, trial file. It's not illegally possessed. Otherwise, I guess the feds would be involved in this case, Your Honor. That's why I had the silencer. I can tell you that there was a perception on my client's part that the kid was tailgating. Then there was a brake check, which you can see from the statement and the police reports. And then the kid comes around really close, rolls down his window, honks at him, yells, starts cussing, and it kind of goes from there. It goes kind of south. I think my client thought he could handle the situation. He thought he would diffuse it with the badge. That didn't work. And then at the moment when this all happened, apparently the young man had a phone in his hand. This was at night, and he made a gesture kind of with his hand to the side, which at that moment in time, my client, who was already kind of freaked out, thought it was a gun. And this was an apparent danger case, Your Honor. Police didn't find a gun in the kid's car, but that's what we saw. We actually, in the subpoenas, dug up extraneous acts where a kid had got in trouble at school for posting shots on social media with him with guns. And he's holding it the same way he was holding the phone. When he's talking to the police officers, he's holding it, he's pointing like this. So that's the gesture my client saw in that moment. He made a mistake. We've spent a lot of time on this. The state has spent a lot of time. They showed us a new witness who was the girlfriend of the young man in the car at the time that nobody had ever found. We'd always went, why weren't they looking for the girlfriend? We couldn't find her. We didn't know her name. Ms. Alban did a great job preparing for trial. And that's kind of why we're here today, Judge. I think both sides have kind of met in the middle. Again, my client doesn't have a violent background. It's just thank God that he didn't hit the kid. So that's why we're here.
Oh, is there something else?
Well, I mean, I'm not sure it's clear. The gun was in the car because of going out target practicing, but he had
Right.
gone and met his family for dinner, and he was going home, and they were in the back seat of the car. In a bag, it wasn't as if he routinely carries a gun.
He had been target practicing at his parents' house prior to dinner. He actually had a concealed carry permit, which he's since had to relinquish. The state revoked because of this.
Is there anything else?
No, Your Honor.
Anything else from the state?
Defendant is happy with this resolution. I would, the court would like to hear now, I do have a restitution amount put on the judgment. if you would like.
Yes.
It's $2,463.82.
I'm sorry,
Okay.
just 1 second. If you could repeat that?
$2,463.82.
So is there any disagreement on that restitution amount?
No, I think that was part of the discovery. We actually had the receipt from the repair shop, Your Honor. There,
And where will you have that restitution amount?
Judge, I think it's going to take a couple of months if the court would entertain that. He started this job about June, maybe, and so there's been some lag time, and I mean, he is the independent contractor, so lag time in taking the jobs and getting paid.
All right, just 1 second. Excuse me. Everybody on this side, y'all need to move because probation can't see and they can't hear what's going on. All right, so when do you think it will be, and state your excuse. When do you think he will have that?
If I had, I would say a minimum 2 months.
Yeah, 60 days.
All right. And that's 60 days from today? All right, this is what the court is going to do. The court, and I'm going to tell you, I was considering sending you to jail as a condition. But the state is saying that the complainant is in agreement to this being your sentence. So you can thank the complainant for that. Because sometimes I feel as though people need to have a chance to be alone in their thoughts at the jail to consider everything that is what they've done. And it appears that you've taken that into consideration. And it appears that on this night, everything that could go wrong did go wrong. But don't brake check people. People don't like to be brake checked. That's just my experience from driving. All right, 5 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs. And I'm sorry, what do? You said you're in construction?
Yes, we have new home inspections.
All right, he can do regular random UAs, or either you can do the patch. The patch costs more, but with the patch, it gives you more freedom because probation will put it on and probation will take it off. Patch costs more though. So you can either do regular random UAs or the patch. Proof of employment within 45 days. There's to be no employment as a home healthcare provider or with minors. 120 hours of community service restitution. I'm going to require parenting classes. Once you complete that, the community service hours will be deemed satisfied. MRT, the anger management course. You're to forfeit the weapon, and you're to forfeit your Horseshoe Bay badge credentials. There's to be no firearm possession. There's to be restitution in the amount of $2,463.82 to Joseph Perez, and that's to be paid in full within 60 days. There's to be no contact with Joseph Perez. There's to be no employment with law enforcement or any type of security. There's to be field visits one time per month for 6 months. Are you here in Bear County?
Yes, ma'am.
All right. Probation, is there anything else? All right, and I'm sorry, there's a $1,500 fine that will be probated. Is there anything else that you need from the court?
Yeah, Judge, in regard to employment, if some of the jobs are out of county, I know some are in contiguous counties, but if they're further, does he just, can he get permission to do that if he shows probation where he's going?
Yes.
Okay.
Probation, he's allowed to work throughout Bear County and other counties, but you'll need to provide notification to probation that you're going to be working out of county. Working in county, that's fine. But if you're going out of county, you need to let them know. All right, is there anything else?
And I just, and actually part of the plea bargain was actually to not only just waive, but to actually dismiss the set count two. I don't know if that was clear. You did do it, you waived it, but that is part of the inducement for the plea is that. And it was to be.
Oh, I've already said that it's been waived. It's on the record.
No, I understand that, but they, I'm just being hyper-technical.
No. I understand what you're saying, but I put on the record that
Yes.
it was waived and you all had no objections to it being waived.
Correct,
So
correct.
it will not come back.
Okay.
It's not allowed to come back.
There you go.
'Cause-
That's what I
All
want.
right,
All right,
thank you.
sorry.
No problem.
All
Did you, and I'm sorry, there's an affirmative finding of deadly weapon. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. In this court, communication with probation is key. If there's an issue, you need to let them know about it. If you feel they're not addressing it, you can always come back and address it to court. But whatever you do not disappear on probation. That's not a good look. You understand? All right, good luck to you. Thank you.
Thank you, Your Honor.
You're
Thank you.
welcome. Sometimes if somebody says, well, I'll be the driver to this robbery. Well, maybe if that person would have said, no, I'm not driving anybody, then everybody would have said, well, we can't do this. We're not going to do it. Right. The court has reviewed the documents. Is there anything your client wishes to say?
No.
I understand what the witness stated, but if y'all can explain to me how he commits one aggravated robbery, pulls a weapon on somebody, then in the report he says he's only doing it, and this is from the stipulations. He's saying he's only doing it because somebody forced him to do it, some man he doesn't know, and that he was at Sam Houston High School attending. But my understanding from testimony is that he was homeschooled, and I guess at some point he went to Sam Houston.
Yes, Your Honor. So he transitioned schools because he was finding himself in a position with these kids that he was trying to escape.
All right.
And
So-
so that was part of the reason why he transferred schools to a different location to try to get away from the environment that he was experiencing.
All right. So if somebody can explain to me how he commits one aggravated robbery, and then the next month he commits another, and he doesn't internalize that this is the wrong thing to do.
I think the main thing, Your Honor, that was affecting Alex at this time was his environment and this external pressure, threats, and the people he was around at that time. And with him being so young and trying to understand exactly what is the right decision, how do
How old were
I,
the other people who were with him?
they were around the same age, Your Honor.
Okay.
And it's those situations where, you know, you have a group of young kids, Alex, who wasn't the one, you know, holding the gun to the store clerk, but knows, you know, I'm in this tough position. I'm being threatened at the same time. I know this is wrong. And I want to be clear, Alex from day one has taken accountability for everything.
Right. So if he's saying that he's being threatened, unless the law has changed, maybe it has. I don't, say that I know everything, but if he's committing an offense under duress, then isn't that a defense?
It is, Your Honor. And we talk about these things with clients and how they wish to proceed. And
So he doesn't want a jury trial?
at this time, no, Your Honor.
Okay.
Mr. Avila has been through more than most people since his young life. And there are times when, as a kid, he's trying to make the good decisions with the influence of his parents, moving to a new country, trying to get the health care for his brother. And as we stated to the court, he takes accountability for everything, and he knows exactly where he went wrong. And I think one of the things that spoke the most to me was when I was sitting with Mr. Avila and we were talking about letters from people and family, and he's the one himself that said, I wanted to write something to Judge. And we sat several times where we passed revisions. He's like, I want to make it as grammatically correct as possible. What else? What can I talk about? And that exchange really spoke to, I think, the core of who he was and who he is. He's recognized where things have gone wrong, and he's recognized where things can go even worse for him in his life. And I think that's a lesson that a lot of people who come before the court learn at different times. And so for me to see that growth in him at such a young age when speaking with him, I think is what spoke the most to both the social worker and myself. Mr. Avila is someone who was caught in the wrong place, wrong time, wrong factors. But he is also someone who takes accountability. He is also someone who is trying to carve out steps for himself and create a plan of success. And to see that for someone his age, I think is pretty remarkable. I told him the options, and we've discussed what could happen. And, you know, he's asking the court for probation, and he would like the chance to tell you and show you exactly what he is capable of and how he can turn his life around. And I wholeheartedly think that that chance should be extended to him. Let him prove to you. And if not, the alternative as well. But at least give him this chance to show you exactly what he has learned, what he wants to do, and how he wants to move forward with his life. Not only to correct the harm that he's caused, but also to become a productive member.
All right, state.
Judge, regarding this offense and the letters that I reviewed during the time of his incarceration, yes, the defendant has come to learn that what he did was wrong, but I mean, he knew it back then. And in his letter that he wrote, he's falling on the sword because he knows that he's coming before this honorable court. I think that in reviewing the stipulations, I think that he's displaying a continued pattern of, you know, with the use of other people's SID numbers, that is against the rules that are in jail. So a pattern of continuing criminal behavior. And then also, I mean, this was not just one aggravated robbery. It was, they hit one store and then are, you know, collecting and appropriating property from that store. And then they go back. And these are people that he met at school, I might add, but, and then they go to another store and then a third store. And so while I understand what counsel is saying, I mean, this was a continued pattern of criminal behavior, violent criminal behavior, where he states that he was aware that these robberies were going to occur and still chose to engage in this criminal conduct, Your Honor.
All right. So here's the thing, and I want you to understand my thought pattern and why I'm doing what I'm doing. I talk to children all the time, and you know what I always tell them? If you're with a group of friends and you all are planning a robbery, you might as well go in the store yourself with a gun, because if somebody else went in the store with the gun, it's like you went in the store with the gun. That's the way Texas law operates. And my problem with you is I understand you're young, and that's what I'm trying to balance. I'm balancing the fact that you're young. I'm balancing the fact that you didn't have a gun, because I've had clients before where they're just the lookout. Somebody gets killed, they're charged with murder, they're looking at life in prison. But you were more than just a lookout. You're opening doors for people. And part of the reason why everybody is charged the same is because historically, if you look at the way the law was written, they're thinking that maybe this crime would not have happened but for your participation. Sometimes if somebody says, well, I'll be the driver to this robbery. Well, maybe if that person would have said, no, I'm not driving anybody, then everybody would have said, well, we can't do this. We're not going to do it. But you continued, and it's not just one. So the state is asking for a cap of 10. I'm balancing your age. Hopefully you have learned something. And I'm also balancing the fact that you did not have a weapon. But at the same time, I'm balancing the fact that after everything happened, you all sat around and counted money. Do you even remember what happened to your share of the money, what you used it on?
None of us know.
I didn't spend it.
Sometimes people go to a convenience store, they end up killing the clerk, and you know what? They end up with $20. Is was that clerk's life worth more than $20? Most definitely. Is time going to prison worth more than the $20 you had? So I'm going to find you guilty. Does anybody want to speak to the cap?
Your Honor, we would ask for the lowest possible. We know that the court is taking into consideration everything that is happening. Just so Mr. Avila can get what he has planned, done, and he doesn't waste time in the beginning moving and potentially experiencing more negative things that would harm and actually impact him coming back to the system. We understand the court's position, and we understand the things the court's taking into consideration. And I think this is one of the opportunities where the law allows for just this, where you get to exercise your discretion.
But I am asking for the time. I did review everything that was prosecuted, went over testimony with the witness, which was provided to me, and that was factored into the plea bargain. And I think another aggravating factor is that there were other people that were with this defendant and this co-defendant that were unidentified. And so we would ask for 10 years.
All right, the court is going to find you guilty, and each cause number, the court will sentence you to a $2,000 fine. Time and money to run concurrent. Court will give you credit for any time served. The cases will run concurrently. Court will take in consideration 2025 CR 001801A, 2024 CC 741988. There's an affirmative finding of deadly weapon. The court will request the therapeutic community. Court will sentence you to 7 years in the prison. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it? And did you sign it?
Yes.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. I understand that prison life is extremely hard. If I had all of the money in the world and could build a prison the way it should be built, every inmate would have their own cell. That wouldn't be 4 to a cell, 5 to a cell, or any of this. But I understand that there are bad things that happen at the prison. But here's the thing. Do not waste your time at the prison. There's some free education there. Make sure you do that. If they have a welding program, get in a welding program, and do not become institutionalized, and do not get tattoos all over your body, because people will recognize those as prison tattoos. When you're released from the prison, if you have any problem finding a place for any alcohol issues you have, any mental health issues you have, if I'm still here, you come back here, I'll pick up the phone and find transitional housing for you. All right. Good luck to you. Okay. All right, the court is calling DC 2021 CR 7552, State versus Guillermo Mejia Ortega. Could I have parties announced for the record?
Ashley Jones for the state.
Robert Mauer for defendant, Your Honor.
And are you Mr. Guillermo Mejia Ortega?
Yes.
All right, we have an interpreter here. If you could raise your right hand. Do you solemnly swear or affirm that you will faithfully translate from English into Spanish and Spanish into English, so help you God?
Yes, Your Honor.
All right, if you'll state your name for the record.
Yes, Jacqueline Payan.
All right, you entered a plea to count one of no contest on September 23rd, 2025. According to the plea, the state is opposed to your application. Punishment is to be assessed at a cap of 10 years in the prison. There's a $1,500 fine, Chapter 62 compliance, and no contact with the complainant. Have both parties had a chance to review the PSI report?
Yes,
Yes, Your Honor.
Any objections?
Not from the state.
not from defense judge.
All right, any witnesses from either side?
Not from the state, Your Honor, just argument.
All right,
Same with the defense judge.
all right, state.
Yes, Your Honor. The state would ask the court to consider that these offenses happen against the most vulnerable of our community, children. In this particular case, these children were 10 and 11 years old. The victim named in this plea in count one, which the state proceeded on, she was 11 years old at the time of this offense took place. Your Honor, this isn't something that happened just one time, but as the court sees in the slips, this continued for a period of time against our complainant and against her sister, an attempt against her sister. And the state would just like the court to consider that this defendant took away their essence, that he gave them something they're going to have to struggle with for the rest of their life. And we would ask the court to just take that into consideration and sentence this defendant to the 10 years in the Texas Department of Corrections.
All right, defense.
Judge, I reviewed the PSI with my client and I discussed the facts of the case. My client entered a plea and accepted responsibility for the offense. He's not a citizen of the United States. There is in fact an ICE hold, and he's awaiting deportation once his case is completed. What I'd ask the court to consider is granting his application for deferred and allowing him to be deported to Mexico. He was gainfully employed and I think trying to get citizenship. Obviously, that is off the table now. But I would ask the court to consider granting his application for deferred. If not, I would ask the court to sentence him at the low end of the range of punishment and allow deportation once he's finished his sentence.
All right, and why should I follow this plea? Why isn't he, headed for jury trial?
Your Honor, at this time, the state has spoken with the complainant's family, and this is the agreement that the complainant's comfortable with.
Judge, I can tell you, we negotiated this, I think in good faith, based upon one, not wanting to put the complainants through the possibility of a jury trial. And I talked to my client about the number of cases I tried like this and the potential result. And I think it's in the best interest of both parties. I guess one, for the complainants not to have to go through the trial, and or for my client to get the benefit of a plea bargain as opposed to the range of punishment that could be assessed at trial if he was convicted.
All right, court will find you guilty. Court will sentence you to 10 years in the prison. There's a $1,500 fine, Chapter 62 compliance, so you'll have to register as a sex offender for the rest of your life. There's to be no contact with the complainant, no re-entry to the United States after you've served your sentence, no contact with minors, and no residing in households with minors. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, thank you.
May I be excused?
Yes. State you're opposed, correct?
Yes, Your Honor, and this one, the victim is opposed to it.
Yes. All right, state. I'm sorry, not state, Ms. Abrams.
Judge, Mr. Rivero has been on probation since November 2023. He was placed on deferred adjudication. for a period of 5 years. He has met all of his financial obligations. He's completed all of his programs to include the IPP, the 150 community service hours, and he's abiding by the no contact order. Currently, he's being supervised out of the state of Florida. He's been supervised since April of 2025. The last progress report from the state of Florida indicates that he's been compliant with all the terms of and conditions of his probation. He reports as instructed and maintains open line of communication with his officer. He's maintained a stable residence and has not had any violations of his supervision. I would note that our assistant probation officer did contact the victim, and she is objecting to the early termination. Mr. Rivera would like to address the court.
All right, Mr. Rivera, there's something you wanted to say?
Yes, can you hear me?
Yes.
Thank you very much. Excuse me. First of all, good afternoon, and thank you very much for allowing me to be in this hearing today to basically provide additional detail from my point of view on this particular case. So I'm going to break this up into 3 different points, right? The first was going to be the positive of this particular case in the situation, the negative, and also the future state. In this particular situation, ma'am, and I have had time to reflect, right? I've had time to reflect to see my wrongs in the situation and what I could have done differently. At that particular time, I had probably a little bit of coping skills, right? I didn't have many coping skills at all to handle those type of situations. Excuse me. I have to like the lady mentioned, I have taken the classes and gained skills, to actually avoid those type of situations and just nip them in the bud and avoid this at all costs. So I've also learned how to deal with that and avoid conflicts. Like how she stated, I have fulfilled my community service and all the other obligations that the court requested. As well positive, I have reached out to my psychiatrist / therapist, and I've spoken to them about the situation, so I do have professional support, right? And I also have expanded my network and reached out to family members, and built those relationships back up, which I did not have and lost and during that relationship, and that I was basically alienated and isolated from my family, which is not good. As well, I have, besides growing my support network, I have also, moved to Florida, like how she did mention. My life has been in Florida, right? I was doing great in Florida. I was thriving in Florida. I've been educated in Florida. My life has been in Florida, right? So I am back home, and I'm grateful for the court to allow me to come back here. Those are the positives that I've taken out of the situation. Right, the negatives, and I'll be quite candid in these negatives, right? So my career currently is on hold, right? So basically in the banking and finance industry with this type of case, I can't be bonded, right? And when in terms of bonded, that means insured, right, by the banks due to regulations, right? So I can't technically.
Mr. Rivero,
Yes,
this
ma'am.
is what I want to let you know. This is your problem. Your problem is with the nature of this case and the fact that the complainant is still going through certain things, and the complainant still states that they are in fear of you. Sometimes when people are on probation, they abide by no contact orders or no contact orders. Then once they're released from probation, then they do whatever they want to do. Do I think that you will contact her? No, but I don't have a crystal ball to show that to me. What I can tell you is the complainant has stated that they're still going through the ramification of your actions. And what they're going through is having facial surgery And, the state is the one that offered you this deferred adjudication. So I'm not going to grant early termination. But what I will do, because you've completed everything, I will allow you to report by mail. But as far as early termination, the answer to that will be no from the court.
All right, thank you.
All right, thank you. What is going on? Why you are not ready to
Requesting
proceed?
a reset. Your Honor, he was extradited down here from Arizona. There's just the DA and I conferred, and there needs to be some investigation to exactly what happened when he was there and he was in California. What's been going on for the last 3 or so years. We just don't have enough information at this time. So we're asking for reset for further investigation before we try to work something out, hopefully. And I provided the state with the case number from his case from Arizona, and I think they've already gotten their investigator looking at it.
Yes, Your Honor, we are started, we do need to reach out to the county Arizona prosecutors to defend.
All right, so I don't understand why. Like, this motion was filed July 24th. And what's filed with the court, the case from Arizona is already attached. So that means that somebody already knew about this somewhere, because the indictment and everything is attached to the motion. So I don't understand.
Your Honor, there's some wording in the order that we need to confer with the prosecutors. It appears that in one of the judgments, there may have been, they may have ordered it to run concurrent with this case. I have the same thought.
Well, I don't have to run it concurrent with this case. So whether they're ordering it or not, that's not a hindrance to what the court does on whether something runs concurrent or not. Similarly, if I were to say this is to run concurrent with the federal case before the federal case is resolved, the federal case does not have to run it concurrently. Now, normally, if there's a sentence that is happening in another case, normally I run it concurrently unless there's a reason not to. So whether or not they ran it concurrently or not is not a hindrance to this case moving forward. So that's off the table, as we need more time to see if they ask that it be ran concurrently or not. So what's the next issue? Just doing what investigation on what? Because if he's already pled to it and that, if he's pled to these cases there, if he entered a plea of guilty, then what? Is he going to come here and say not true when he's already pled guilty? So I don't understand.
Yeah, and I think just from what defense and I were discussing, we wanted to see what he pled guilty to as there are violations. I know there's one judgment there. It looks like the narrative of the court summary, there may have been 2 charges and those ones picked up 5 additional ones. I didn't know the outcome of those. So that's what I was working with my investigator on.
All right, all they have to do is pick up the phone and call somebody that they'll answer.
Additional judge, I don't think you have the supplement. There's a supplement. Do you have a supplement MTR? Which does include some technical.
I have a first amendment amended.
There's the vast majority of the violations are from Yuma, Arizona, but at the very end of the first or second supplement, I believe there's 3 technical violations.
Well, he has the unlawful use or transportation from Yuma, narcotic drug possession, Yuma. So that's on the first amended.
At the very end of the last motion that was filed by the state, there's 3 technical violations.
All right, so let me ask you this.
Yes, sir.
So is he sentenced to federal custody? Has he been sent to prison,
He's done,
federal prison?
but not federal, right?
No.
All right, so has he been sent to prison in Yuma?
He did about 2.5 years, Judge.
All right, so technicals are what's going to hold this up. All right, so this is coming back tomorrow, and you all need to call whoever you need to call. That's
Did I
what
have-
phones are for.
I can't be here tomorrow. I have a,
I'm sorry?
I can't be here tomorrow. I have a medical procedure.
Okay, all right, so I'll see y'all back this afternoon. Call whoever you need to call.
Judge. I have to prepare for this afternoon.
No, I understand. I want to make sure that you all have all of the information because nobody's called anybody. So I'm not saying it's going to go on a contested hearing, But you all need to pick up the phone and call Yuma County or whoever you're gonna call to see what information they have, because in the court's documents, and this is just something that's attached to the motion to revoke, they already have the Arizona in the document. So pick up the phone, call somebody.
Yes, we're already ready.
All right, okay, all right, thank you.
I can't be back this afternoon.
Okay.
Monday?
You really scared me and I just didn't want to come back here. That's why I would run.
All right. Court is calling 2022 CR 9805 State versus Fernando Carmona III. Could I have parties announced for the record?
Lauren Espinoza for the state.
Andrew K. Hicks for the defense.
And are you Mr. Carmona?
Yes, ma'am.
And are parties ready to proceed?
We're ready to proceed, Judge.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilty and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Fernando Carmona III who was placed on deferred adjudication in 2022 CR 9805 for the offense of aggravated robbery on February 3rd, 2023 for a period of 10 years? Is that you?
Yes, Your Honor.
All right, state.
On state's first amended motion.
Oh, I'm so sorry. And also, did you review the First Amendment motion with your attorney?
Yes, Your Honor.
All right, you may proceed.
Violated condition number 1, on or about the 22nd day of November 2025 in Bexar County, Texas, the defendant Fernando Carmona III committed the offense of failure to ID fugitive intent to give false information in violation of condition number 1.
All right, to that, how do you plead? True or not true?
True.
Violated condition number 1, on or about the 22nd day of November 2025 in Bexar County, Texas, the defendant Fernando Carmona III committed the offense of evading arrest detention in violation of condition number 1.
How do you plead to that?
True.
Violated condition number 4, in Bexar County, Texas, the defendant Fernando Carmona III did then and there fail to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, and October 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
And finally, violated condition number 4, in Bexar County, Texas, the defendant Fernando Carmona III did then and there fail to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, October, November, and December of 2024 in violation of condition number.
How do you plead to that? True or not true?
True, Your Honor.
State will waive the remaining.
Any objections to the waivers?
No, Judge, none, Judge.
All right, did you understand by pleading true to violations 1, 1, 4, and 4, the court could find it true, grant the motion, find you guilty, and sentence you up to life in prison
Yes, Your Honor.
and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violations 1, 1, 4, and 4?
Yes, Your Honor.
Court will find 1, 1, and 4 true. Is there a proposed agreement?
No, there's not, Judge. We have differing opinions, so the state's position is to grant state's motion, revoke probation, enter an adjudication of guilt, and sentence to 18 years in the prison.
All right, so I need a trial court certification. I don't have one.
Judge, I actually have one right here. I went over with it. He's, my client's a little emotional at the moment and didn't want to sign it. We're willing to stipulate on the record if perhaps that that I have gone over his, the certification of his rights to appeal. And I've explained to him that any actions that you take here today, technically he would have the right to appeal, but he cannot appeal his underlying case.
All right, did you not want to sign the trial court certification of defendant's rights to appeal?
Yes.
It's oh, okay.
You'll sign it? Okay. We'll have it signed right now, Judge.
Right.
You understand that? Yeah, right there. And so, Judge, we're going to go ahead and tender that certification of right of appeal.
All right, so the state is asking for revocation for 18 years. Defense, do you have any witnesses?
Your Honor, we have no witnesses, although except for my client, Mr. Carmona himself, he's willing to answer any questions that the court might have, and also wants to say a few words on his own behalf.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Fernando Cremon.
All right, let's get to the crux of things. Why did you never report?
I was going through a lot at the time. I had a miscarriage with my girlfriend, and then my daughter's mom wasn't letting me see my daughter that I have right now, and I started taking a lot of drugs, and I just let time pass, and I wasn't really in the right state of mind.
But you were in the right state of mind to commit new offenses.
I had just panicked whenever I saw cops, and I just tried to run.
Here's the thing. I don't think that you're a good candidate for probation.
I understand that.
And the reason being is because you were given a chance at probation.
Sure.
And I'm sure it was because of your age. The state recommended for you to have deferred adjudication. And when they did that, they took into consideration 3 cases.
Yes, Your Honor.
And so you're not a good candidate for probation. Have you done anything while you've been on probation?
I tried to report for the first time, but then I'm sorry, Your Honor. I just had a lot of that had happened at the time, and I was just emotional, and I just wasn't who I am. I'm sorry.
Well, no, I mean, here's the thing. I understand that sometimes people want to turn back the hands of time, but you can't. So we just have to deal with where we are now.
Yes, Your Honor.
And where we are now is, according to what I'm seeing, you have not done anything
Yes, Your
on
Honor.
probation, except pick up new cases.
Yes,
And
Your
that's the number one thing. The easiest thing is to report, because all that, I mean, it takes time because you're sitting, waiting for whoever your officer is to call you back and not pick up any new cases. You know, when people say, well, I don't belong to a gang, I don't pick up new cases, I pay my child support, it's always you want a cookie for that because everybody does that.
Mhm.
Like, you shouldn't get kudos because you pay child support, right?
Yes, Your Honor.
And you're telling me that the mother of your other child didn't want you to see that child?
Mm-hmm.
Well, I mean, you come to her on probation for aggravated robbery. Why would she want you to see her child? And then you're picking up new cases and whatever else you had going on in your life.
The most thing that threw me off was the fact that I had a miscarriage, and I was just really down about that.
For 2 years.
Yeah.
And I understand, and I don't want to make light of it. Anytime you lose a child, that stays with you forever. But I don't see how that translates to you never showing up.
I understand that.
And when you said there was a miscarriage, what month was that?
It was. I'm not really sure. I can't tell you the exact month.
Well, I mean, was it?
I just fell into depression.
But when?
Around I had met my probation officer, and it was like a month after that.
So, I mean, when would this have been though? That's what I'm trying to figure out.
So if you began probation, let's figure this out. Back in February of 2023, and you said that you made a visit.
Oh, yeah, it was around April.
April what?
2023.
Yeah. I just don't think that you're a good candidate.
I understand that.
Judge, if I may, on his behalf, I mean, you can see he's obviously very emotional here today. First thing that he told me, especially when I told him what the state was offering, was he's scared to death.
I'm sorry. It's just the last time I'm so sorry. It's the last time I saw you, you really scared me, and I just didn't want to come back here. That's why I would run.
Yeah, because I mean, here's the thing. You've been here before. This is not your first motion to revoke. And I do understand that sometimes when you're dealing with young people, and you're young,
Yes,
right?
Your Honor.
That is why the first time you came back, there was not a revocation.
Yes, Your Honor.
And the mother of your child, what's her name?
Felicity.
All right, that's the mother of your child. And
Yes.
then there's someone different.
Huh?
All right, so here's the thing. The last time you were here on a motion to revoke, you know what I put in place?
No, I don't.
No contact with Felicity.
Uh-huh.
And here you are trying to get in touch with her so you could see your child. The last time you were here, there was to be no contact
Yes,
with Felicity.
no, it was my sister that was trying to like get her so that I could see her.
Okay. Yeah,
Because I have nowhere to be or anywhere to live, and my sister had a house, and she just told me that she'll be able to take my daughter in so that I could see her.
Mhm.
I wasn't contacting Felicity.
yeah. I just don't think you're a good candidate for probation.
If it would please the court, Mr. Carmona, who has been in touch with me pretty extensively, both in person and through his girlfriend, has prepared a letter for the courts that
Any objection?
no objection. It's just a heartfelt something. As you can tell, Mr. Carmona doesn't really do the best job putting together his own words, and he just put his thoughts down on paper.
No objection from the state judge.
Thank you, Judge. Thank you, Judge.
Thank you. So, Mr. Carmona, you've been on probation since 2023
Yes, Your Honor.
and you haven't done anything. The only thing you've done is not report and pick up new charges.
Yes.
I don't think you're a good candidate for probation. So I'm going to grant the motion and I'm going to find you guilty. The only question is as it relates to length of time.
Judge, with regards to the length of time, again, we would ask that the court please take into consideration Mr. Carmona's age, as Your Honor has already risen. I'm sorry, I'm getting over a cold. My mind is still a little bit in flux here. As the court has already raised on its own accord, he is very, very young. I believe that this incident took place when he was 19 years old. He's 23, about to turn 24 years old right now. Obviously, this underlying incident, I understand that there were some pretty bad facts in this case. Nevertheless, I would please ask that the court please take into consideration then the time that has passed since then. He does actually have a girlfriend who is here in the courtroom with him, who has set him for the most part on the straight and narrow since then.
Is this the person who had the miscarriage?
Yes.
Okay.
And she has cared deeply. She has been in touch with me pretty consistently. She's been looking out for him.
And how old is she?
I'm sorry. How old are you again? Sir? She's 19, Judge.
She's 19 and you decided to attach your star to somebody who is on probation for aggravated robbery, decided to have a child with him. And the only thing he's done on probation has been pick up new cases and not report it. Is this what we're doing in this world?
Judge, I can't speak to her choices on this there, but she sees something in Mr. Carmona and she has really taken an interest in him. And as such, I would just, again, I can speak from a personal experience, Judge, that as a man, I was a different man from when I was 19 to 24 and then to what I am today. There's a reason why they say the brain doesn't stop developing until you're in your late 20s, especially as men. And I see that Mr. Carmona, I mean, when I met him, I kind of ran the full gamut of emotions there. I mean, admittedly, he was a little bit cocky when I first met him, and then he got a little concerned, a little frustrated, and now today I see this very scared young man. And right now he is very, very much staring down the fact that he could be spending the rest of his life in prison. And again, based on the facts of, as I understand them, because I did not handle the underlying case, I've been handling only the MTR. I don't see anything here that would warrant him spending 18 years of his life where he would then get out and be in his 40s. He would, I'm going to be turning 50 pretty soon, but I can only imagine myself starting my life essentially 9 years ago. So I just don't see that the facts warrant that here. I ask that the court please take mercy on him in its sentencing, and please allow him to get another start at life. I think with some structure, he might actually show some potential.
Before you met her, did you tell her you were on probation for aggravated robbery?
Yes.
And did she give you any advice to, hey, you need to report?
She was scared for my life too. Because the last time I was here, you had told me that I wasn't gonna get life if I ever came back here.
No, I'm sure what I've said was, from here on out, everything you do, you need to ask yourself if the actions you're taking, if that could result in you potentially going to prison for life. If it is, don't do it. If the answer is maybe, don't do it. And I'm sure I probably told you, if there's anything that you need, speak with your probation officer. If you feel they're not addressing it, you can always come back to the court. You did neither. Instead, what you did was not report for close to 2 years and pick up new charges. All right, the court is finding 1, 4, and 4 true. The court will find you guilty or revoke. I'll request a therapeutic community. There's an affirmative finding of deadly weapon. There's to be restitution to Miguel Zapian, if any. There's a $1,500 fine, time and money to run concurrently. There's to be no residing in households with minors, and the court will sentence you to 14 years in the prison.
Judge, may I just please ask for reconsideration for less again, just based on everything here, Judge. I do appreciate that this was less than the 18 years that the state asked for, but again, may we please ask for reconsideration?
Thank you for your arguments, counsel. Did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is not a plea bargaining agreement. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion that the court found true, which was 1, 4, and 4. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Mm-hmm.
All right, so your complete sentence from the court is 14 years. Therapeutic community, I cannot force them to place you in the therapeutic community or order that. You'll have to request it as well. There's an affirmative finding of deadly weapon, $1,500 fine. That fine will run concurrently with the time you serve, and there's to be no residing in households with minors. All right, good luck to you. Who's ready?
I have Arlene Good, Brandon Garcia. Page 8, 1 down.
Brandon Garcia. Hello. All right, so what are we going to be doing with this case?
So we spoke with the family. I believe we're going towards contesting NTR where we wrap the cases up that way. Rather than filing a consent.
Okay. All right. Ms. Ferguson, can you state when will you be ready on a contested hearing on Mr. Lampkin? All right, if you'll give me a 2-week reset. And are parties okay with witnesses appearing by Zoom?
Yes, Your Honor. We are going to be in trial in both Bear and Kendall over the next 2 weeks. Would it be possible to have a date closer to 3 or 4 weeks now?
State?
Yes.
Defense say they will be in trial in 2 weeks in another county, Bear County, and then someplace out of county. Are you okay with moving it to 3 weeks out?
Yes, Your Honor.
All right, thank you. All right, Ms. Ferguson, a 3-week reset for a contested hearing.
Well, we're gonna say day 3.
Yes.
We're gonna be doing our mistrial for punishment in the 290th on the 17th. So I think the 20th would be best for us.
All right, November 20th. Yes. All right, so continue taking your medications, following the doctor's orders. You understand? All right, and listen to your grandfather. And counsel, I believe everything has been signed.
I don't believe so, Judge. We just have the motion to allow him to go trick or treating with his family around his neighborhood.
All right,
State is opposed.
all right. State, do you want to be heard on the defense's request?
Or, oh, the trick or treating, Judge, I mean, we're not in agreement on that, but.
Do you need a hearing?
Or you could just notate that.
All right, so this is what I'm going to say, and I know the state is aware of this. Because of his mental health issues, he's always with his grandfather, and if his grandfather is going to be out of the house, it's best for his mental health, and the court is going to find it best for the safety of the community that he is with his grandfather. So, could I have the grandfather come up, please? All right. Sir, I know that, good morning. I know that you're responsible for other people in your household as well. With regard, you're responsible for him.
Yes.
All right. So with regards to this, going to different neighborhoods for trick or treating, why is that needed for him?
It's only because where the relatives live, one uncle lives in Camelot.
Mhm.
And then we go by the church on Judson Road.
Mhm.
And so they do that trunk or treat.
Mhm.
And so we go to the church and then we go to where his uncle is in Camelot. So it's about like 30 minutes away.
Mhm.
And then there'll be all the little kids and stuff like that, you know.
Okay, so why does he need to go? That's what I'm trying to figure out.
Oh, because the family all goes together. And like,
Ah.
you know, like the church has that hayride thing
Yes.
where you sit on it and.
Okay, I understand now. I thought that you're taking him, because sometimes I see adults trick or treating and they don't have a child with them, and I'm like, come on, this is not for you. But now I understand.
And plus, Your Honor, there's a new, he's an uncle, there's a new grandbaby,
Mhm.
a 1-year-old now. So it'll be his first year for Halloween and stuff. So
Okay.
that's all.
All right. So are you dressing for the festivities?
Am I?
in a costume?
Oh, no, I'm just going as my old military style look.
Oh, okay. All right. I'm always interested in what people will be wearing. So State, I understand your objections, but I also.
Your Honor, I went as a sheik,
When as a what?
SHEIK.
Ah.
And I had two ladies go with me, kind of the chic in his hair. Oh, I just thought I'd tell you that.
Okay.
That's right. I'm sorry, too much.
Yeah. All right. So this is what I'll do. I understand his mental health issues. And because we've had so many hearings with him before with probation, and we've had previous input from his doctor, I understand this is what he needs to maintain his mental health. So I will grant it. However, he can only do this if you are present.
Oh, yes, I'll be present.
All right. So if you all will add that, and I will sign it.
Thank you, Judge.
All right. And then Ms. Ferguson, if you'll have a seat, Ms. Ferguson will give the reset form, and once you sign that, you'll be excused.
Thank you, Judge.
Yes, just have a seat. Yes. Thank you.
Thank you.
You're welcome. Their vehicle is T-bone, so that probably means that their vehicle is not drivable. The court is going to call Sebastian Gabriel Marino. Can I have the parties announced?
Megan Galloway for the state.
John Pettis for defense.
And are you Mr. Marino? Counsel, you received all discovery. Did you review it with your client?
Yes.
The court will find that the state is in compliance with discovery. Mr. Marino, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, sir.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Marino, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with evading arrest, detention with a vehicle that's a third-degree felony? Range of punishment is anywhere from anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
He was, Judge.
Mr. Marino, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Oh, yeah.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, sir.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, punishment is to be assessed at 8 years in the prison. There's a $2,000 fine. The state recommends community supervision. There's no application for deferred adjudication. Taking in consideration 2024 PF 23175, 2024 PF 176. Did you understand that to be the plea?
Yes, sir.
Defense?
Yes, Judge.
State?
Yes, Your Honor. I'm sorry.
That's okay. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. There be a TAP evaluation, 200 hours of community service restitution, the MRT, and aggressive driving. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
Then to the offense as charged, how do you plead?
No contest.
State any evidence.
State offers stage 1 in attachments.
No objection, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right. The court will find there is sufficient evidence to find you guilty. The court will find you guilty. Is there any outstanding restitution?
Judge, we've not received documentation regarding that. So at this time, I believe we would waive.
All right. How old are you?
I'm 23.
All right, you're 23. Did you drive here today?
I got dropped off.
All right. So why are you doing this?
Well, to be completely honest with you,
Yes, please be completely honest.
I was going through the beginning of my divorce at the time. I had been with my ex-wife for about 6 years at that point.
Mhm.
It was just kind of one thing after another. And it escalated what it shouldn't have. And I've done a lot of different things now. Now I'm a volunteer firefighter. I do try to be there as much as possible.
So you say you're a volunteer firefighter. What is your employment status?
I work at a shop. I'm a technician.
You're doing what?
I work on vehicles.
Mechanic.
Yeah.
Do you have any children?
I do have a 2-year-old daughter.
All right, this is what the court is gonna do. The court will sentence you to 8 years in the prison, suspended and probated for 6 years, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors. Taking consideration 2024 PF 23175 and 23175, 23176. There's a $2,000 fine. With regards to a $2,000 fine, the court will probate that. Field visits 1 time per month for 6 months. Defensive driving course. There's to be no driving for 6 months. MRT, 200 hours of community service restitution. Once 100 hours are completed, 200 hours of community service restitution. I'm going to require parenting classes. Once the parenting classes are completed, 100 hours will be deducted from community service restitution. The remaining 100 hours will be deducted upon completion of MRT. There's to be a TAP evaluation out of custody, follow recommendations. And there is no restitution order. Probation, is there anything else that's required? No, Judge. Is there anything else you need from the court to be successful?
That's the question. I know you said no driving for 6 months. That does tend to make it a little bit harder because I do try to get as much side work as I can just to help, keep up with my bills and everything.
Okay, let me ask you something. You were driving in recklessly, right? And then you were evading. And what happened when you were evading? I'm sorry?
There was a car accident.
Yes, and that other person, what happened to their vehicle?
I'm not sure.
Their vehicle was T-boned. So that probably means that their vehicle is not drivable. And you know how insurances are. Sometimes they'll give you a loaner, sometimes your insurance doesn't cover that because it's just liability. So this is the cost of your doing something that you should not have been doing and you were old enough to know better. And if that person would have had a 2-year-old in the vehicle, who knows what would have happened? You understand? So this is a part of your punishment. You understand?
Yes, sir.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
All right, because this is plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to the attorney. Do you understand?
Yes, sir.
All right, good luck to you.
Repeat it.
Yes, they'll go over conditions with you. Ms. Abrams, who do you say was still pending? You admitted that you're the person who purchased the weapons. Court is calling 2025 CR 010997, State versus John Jacob Gomez. Could I have parties announced for the record?
David A. Garcia, attorney for John Gomez. Good morning, Your Honor.
Good morning. Are you Mr. Gomez?
Yes, Your Honor.
All right. Both parties waive PSI.
We did, Judge.
According to your plea bargaining agreement, punishments be assessed at a cap of 8 years in the prison. This run concurrent with 2023 CR 6499B. The state is opposed to your application. Is he currently on probation?
He's on parole, Judge.
Parole. Right. Are there any do you have any witnesses? Defense, any witnesses?
And Judge, I think the case that he's on parole for is a 2003, not 2023.
Oh, I'm so sorry. 2003 CR 6499B.
No witnesses, Judge, just argument.
All right.
Your Honor, the state's position is that Mr. Gomez is not fit for any type of community supervision, but rather for incarceration. He has already done 3 previous trips. The most recent being for an ag robbery in 2004, so because of that.
All right, defense.
Judge, I understand the state's argument. On paper, it looks bad, but Mr. Gomez here, he went to prison for a case out of 2003 for an ag robbery. He sat in prison for about 17 and a half years. He got out on parole, has been working at Paisano's restaurant as a chef for the last 4 years. He was helping to raise his three boys, helping his elderly mother. Everything had been going well. He was doing well at work. What was the name of the chef you were working under?
Under Chef Raul.
Under Chef Raul, he had high hopes. And it's true that the path to hell's paved with good intention, Judge. His brother needed someplace to stay. He felt he couldn't let his brother live out on the street, so he let his brother live with him. Unfortunately, the brother ended up having a warrant for his arrest. When a warrant was executed at his house, they came in, they found the brother, they found a gun. Because it's his house, he was charged. Mr. Gomez knew he could take this to trial. He didn't want to waste anyone's time, waste the court's time. He knew that he made a mistake by having his brother live there. It was his house, thus he was in possession. And so we took this plea. We're hoping that you give him this opportunity to prove himself. I know it's based on his record, it looks bad, but you know, he did spend his time. It was 22 years ago that the ag robbery occurred, and he was trying to do well. If you can give him an opportunity, he can prove himself, Judge. He's willing to abide by any condition.
All right, is there anything you wish to say?
No, Your Honor.
All right, in the stipulations, you admitted that you're the person who purchased the weapons.
Yes, Your Honor.
All right, so, I mean, I don't think you're a good candidate. I mean, you should have known you can't purchase weapons. All right? So, the court is going to find you guilty. The state is asking for a cap of 8 years. Is there any argument with regards to the cap?
Just simply, Judge, that he was trying to do well. He knows he made a mistake. He's accepting responsibility for it, Judge, by taking this plea and not making the state take him to trial and waste the court's time. So we're asking that you be as lenient as you can.
All right, and state.
The cap is more than generous considering the prior criminal history, so we just ask the consent.
All right, the court will follow your agreement. The court will find you guilty, sentence you to 8 years in the prison, give you credit for any time served. There's $1,000 fine. Time and money will run concurrently. This will run concurrent with 2023 CR 6499B. I'm sorry, not 2023. It will run concurrent with 2003 CR 6499B. Is there anything else with regards to sentencing?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and as you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. You know what position you're in. You know, if you don't know, if you didn't know before, you now know. You're not allowed to possess weapons. You're a felon, right? And you shouldn't let anybody in your space that is going to potentially result in you being charged with something that's illegal, because you know what you're facing. All right, good luck to you, okay? Is anyone else?
Yes, ma'am. Joshua Sutherland, page 2, 4 down.
What were you thinking?
Good afternoon.
Good afternoon. Court is calling 2024 CR 012217 State versus Jorge Alberto Cuellar Guevara. Can I have parties announce?
Jeffrey Art for the state. Orlando Castanon for defense.
And are you Mr. Guevara?
I'm sorry?
Yes, is that you?
Yes, ma'am. I'm sorry.
All right, no problem. I'm sure I'm probably mispronouncing it. I'm sorry. Counsel, have you received all discovery?
Yes, Judge.
Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Guevara, did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented? Mr. Guevara, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with online solicitation of a minor for sexual conduct?
Yes.
That's a second-degree felony.
Yes.
Range of punishment is anywhere from 2 to 20 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
All right, why should I follow this plea?
Judge, he has no prior criminal history. He's accepting responsibility. We discussed some defenses to this case, but in light of I think all the facts, I believe that he thought this is in his best interest to pursue, and as such, we're asking you to follow this agreement.
What were you thinking?
I wasn't thinking.
And how old are you?
34. I was going through rough times. It's not an excuse. I'm defending.
No, and let me just tell you something.
Yes, ma'am.
So obviously, if this were an actual child on the other end of the line, you were trying to take advantage of them, right? And I'm just telling you, you cannot build your happiness off somebody else's misery. And if that were a child, and if you were to actually have met that child,
No, yeah.
You understand?
Yes, ma'am.
all right, the court is going to find you guilty, sentence you to 3 years in the prison. There's $1,000 fine. Chapter 62 compliance. There's to be no residing in households with minors and no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal because this is a felony conviction. You're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, ma'am.
Counsel, they always say, if somebody says, yes, 100%, that means they're telling the truth. If you ever watch Maury Povich, when they're saying you're not the father, whenever somebody says, I'm 1,000% sure, anytime they go over 100%, it's not true. So he really meant that when he said 100% satisfied. All right, thank you. Oh, thank you, you too. All right, so you all agreed on an amount, $3,700.
Yes, Your Honor. That's what the victim, there's a document in there that came from Target, because this occurred at Target where he was employed. There's a document in there from Target where they, I guess, interviewed the defendant about the items he stole, and he admitted to the amount specifically that's requested by the state.
All right, so when are you going to pay for this?
I can pay payments over time, Your Honor.
So when you say you can pay for this over time, how much are you talking about per month?
A month, I can pay 500.
All right, so can you pay 500 per month, or are you just telling me what I want to hear?
No, yes, Your Honor, I can pay 500.
Do you have employment?
Yes, ma'am. Yes, Your Honor.
All right. All right, court is calling 2025 CR 003791, State versus Andrew Xavier Crawford. Can I have parties announced for the record?
Melissa Albin for the state.
Keith Engelke for Mr. Crawford.
And are you Mr. Crawford?
Yes, sir.
All right, you entered a plea of no contest on September 16th. And according to this, he was to pay $500 already. So has he paid $500?
No, ma'am, he's not been able to do that.
Why not?
I get paid for my employment tomorrow, and I was gonna have the money today, but why? Sometimes my check comes early, but it's not like always the same. Like, you know, it's not always the same time, and I get paid tomorrow. I was gonna have.
State?
Yes, ma'am. He said that he would have the money today and or by now, and he hasn't. So obviously that raises concerns.
All right, so here's the issue for the court. The issue is that this was set on September 16th. You enter a plea, and the court, you said you would pay $500 by the next setting.
Yes, sir.
So here we are in December.
Yes, sir.
So when are you going to have the $500?
I can have it tomorrow. I can bring in the money to.
All right. Your bondsman did an affidavit to surrender surety. So what I'll do is I will, how are you paid?
Weekly.
No, I mean, are they doing those things where they give you a credit card or direct deposit?
Yes, yes, sir.
All right. What I'm going to do is I'm going to send it to you today, and I'm going to order that $500 be paid towards restitution tomorrow. If it is not paid, a motion to revoke will be filed. Do you understand?
Yes, sir.
All right. State you may be excused. Are you Xavier Crawford?
Yes, ma'am.
Can you raise your right hand for me? Yes. All right. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right. So what do you do for a living?
I work at BJ's.
Okay. And do you have any children?
No, you're.
Do you have family support?
Yes, sir.
And who is your family support? Right. Do you live with them?
Yes, sir.
All right. All right. This is what the court is going to do. All right. Yeah.
Yes, sir.
This isn't a motion to revoke. Okay. Oh, that's okay. I'm gonna white it out. All right. And have you had any type of mental health issues in the past? All right. The court is going to sentence you to 5 years deferred adjudication. Just one moment. All right. The court is going to sentence you to 5 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 40 days, no employment as a home health care provider or with minors. There's to be restitution to Target in the amount of $3,746.99. And I don't know how he's going to pay the 99 cents because they're doing away with the penny. So $500 to Target, that needs to be in a money order or cashier's check, is due on December 16th, 2025. There's to be 200 hours community service restitution. Why is there a request for healthy relationships?
This was not meant that we were up for that. They've got probation, this.
All right.
My understanding is it'll be taken into consideration.
All right. So there's to be 200 hours community service restitution. 100 hours will be deemed satisfied upon completion of the healthy relationships course, which I'm ordering. The remaining 100 hours will be deemed satisfied upon the completion of the anti-theft course, which I am ordering. And have you had any type of mental health issues in the past? All right, there's to be no contact with Target. That's any Target. So don't go to any Target. Or Michaela Peon, Pean. There should be field visits 1 time per month for 6 months. With regards to a case to be taken in consideration, it's not in your plea bargain agreement.
It's my understanding was to be.
I mean, it's not listed. State, is there something that's being taken in consideration?
I
Okay.
can provide you with the case number.
Well, no. I'm just saying what your plea bargain agreement is with this court. There's no TIC. If the state is saying there's a TIC, then the court will, of course, follow that, but that's not in the plea bargain agreement. Probation, is there anything else that's needed? Is there anything else you need from the court in order to be successful?
He has a setting on the outstanding misdemeanor today.
All right. And could somebody look and find out, is he taken into custody because the bondsman did an affidavit to surrender surety for this case?
He was supposed to come to sentencing in October 23rd. And then the affidavit surety was filed.
Okay.
He failed to appear.
And I issued a judge's warrant and remanded with you without bond on October 23rd. Why did you not appear?
Because I had an accident.
Because what?
Because I had an accident in the morning.
An accident what?
An accident in the morning.
What type of accident was that?
I was taking my brother to school in the morning for my appointment, and I got rear-ended.
And did you inform your attorney of that?
Like hours later.
The court didn't receive notice of that, because if the court would have received notice of that, the court would have recalled the warrant.
Yes, sir.
So what information did you tender?
I didn't get to.
The judge, he called me, I appeared, I notified you. You asked me where he was and some other questions. And I tried to obtain information from the clinic, and the clinic sent me the document that I could not open. So, and then Norma indicated that she would just reset the case.
Normally what?
The coordinator indicated that she would reset the case to a different date. And
I usually have request information. In order for the case to be.
right, and we did furnish a request from the clinic to excuse him from court. And I believe you indicated to the coordinator that wasn't sufficient. So I tried to get something more.
No, I mean, in this court, if somebody says they've been in an accident, they need to provide documentation. So my question is, was documentation ever provided to the court?
Beyond what I just described, the request from the clinic, no.
All right. So, yes.
I just wanted to let the court know that he does have a misdemeanor harassment case, and as part of the agreement that Megan made with defense counsel, it's to be judgment satisfied, not TIC.
All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand, counsel?
Oops. Sorry.
All right. So the court will recall the warrant since this case is closed. And I'm only recalling the warrant for cause number 2025 CR 003791. So if he has a warrant elsewhere, he needs to take care of that. All right. Good luck to you.
Thank you, Judge.
And you need to have that paid. Otherwise, a motion to revoke is going to be filed.
Yes, ma'am. And where do I bring it? Where do I bring it?
You speak to probation and they'll let you know. Thank you. You're welcome. Who's next?
Page 6, first one, Arnold Cabana.
Why are you threatening to send out videos? All right, so it appears that she doesn't want you anymore.
Judge, there is a gentleman here from Wisconsin.
Sorry?
There's a gentleman here from Wisconsin. He's seen 400 of your episodes, and he wanted to personally meet you. He told the bailiff, and he came in, he's here visiting.
Where is he?
Mr. Cook? Mr. Cook, could you stand up, please?
Hi, Mr. Cook. Are you Mr. Cook?
Yes.
Hi, Mr. Cook. I'll come out and meet you in a little bit, okay? After I call the docket. All right. Welcome from Wisconsin. Thank you. Yes.
You're a celebrity now, Judge.
No, I'm just doing my job.
He says he likes your temperament.
Nice. All right. So everyone, please pay close attention. 1, the van or bus, whatever you want to call it, that brings inmates over, needs to be looked at by a mechanic, or is a new one needed? Do we need to take up a collection to get a new bus? So it's broken down. Now, what does that mean? That means you're going to have some extra patience in your pocket. Don't get upset with the deputies if your inmate is not here because the bus is broken down. So they can only bring 10 people over from the jail at a time. Now, why didn't the city design downtown where the jail is next to the courthouses? We may never know. If somebody wants to do some research, we have some interns here. If y'all want to do research on that, you can, to find out why that happened. So you need to be patient. And remember, this is Christmas season. So Santa knows when you're sleeping. He knows when you've been good or bad. So be good for goodness sake. So let's not get upset with the deputies because they only have what they have. And if you have a client who's admin seg, they have to bring them up separate from everyone else. So everyone, please be patient. At 9 o'clock, I am going to call the docket. And Rick, last night I had zero help. Megan, you're to blame. Okay, so you know I love mac ribs, but I haven't had a mac rib in like 2 years. We were here late in court, and Megan tells me, and Bashan tells me, the mac rib is at, McDonald's, it's out. So I'm driving home. On my way home, I stop at McDonald's. It's raining. I go through the line. I ask for the mac rib, and they say we're out. Okay, now mind you, that should have been that. I should have been able to call my sponsors and say, hey, help me out. No, they're like, oh, you can do it. I go to the next McDonald's. They have my mac rib. So that was my dinner last night, and I had no help. No one to tell me, don't do it, Judge.
Honor, you mentioned Christmas. I already know what I'm giving my wife for Christmas.
What?
A second chance.
Johnny, you're so hilarious. All right, everyone, I'm going to call the docket. When I call the docket, you need to stand and let me know you're here. Otherwise, I'm going to assume you're not here and a warrant may be issued for your arrest. For Mr. Carter, if you could state your name, please.
Kyle Simpson.
All right. Have both parties, defense counsels, have you received discovery from the state, and did you review it with your client?
We have, Your Honor, and we did.
All right, court will find that the state is in compliance with discovery. Mr. Carter, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsels, do you waive the reading of the indictment?
We do.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with the offense of publishing or threatening to publish intimate visual material as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? All right, why is everybody whispering today? All right, that's okay. It's like people are whispering for some reason. I can't hear. Court reporters having a hard time hearing. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
All right. Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Counsels, has your client been able to provide you with any defenses?
Yes, Your Honor.
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Yes, Your Honor.
Mr. Carter, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,000 fine and the state recommends deferred adjudication. Did you understand that to be your plea?
Yes, ma'am.
Defense is at the plea?
It is.
State is at the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes.
Just for a moment. Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No.
Outside the
No.
agreement, thank you. Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There be 100 hours community service restitution, TAP evaluation. The state has put zero tolerance. I don't do zero tolerance. You know, either you violate your probation or you didn't, and then I make decisions on that. A mental health evaluation, parenting classes, anger management class, BIP class, no harmful or injurious contact with the complainant. Did you understand that to be your plea?
Yes, ma'am.
Defense is at the plea. Defense is at the plea.
Yes, Your Honor.
State is at the plea.
Yes, Judge.
I'm sorry, not the plea. Did you understand that those recommendations are recommendations from the state and the court does not have to follow those recommendations? And those are the recommendations that the court previously read which is the state is recommending 2 years. So I don't have to give you 2 years. I can give you more than 2 years. 100 hours community service restitution. I can give you more than that. The mental health evaluation, parenting classes, anger management class, BIP class, and the no harmful or injurious contact. You understand that?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest? State any evidence.
State offers State Exhibit 1 and attachments. Without objection.
All right. And
No
state,
objection.
thank you. And state, have you spoken with the complainant?
Yes, Judge, and she's here today.
All right. Mr. Carter, did you review the waiver and stipulations of testimony with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Yes, Your Honor. We'll waive PSI.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. So this, the offense as charged, right? Whenever you see that offense on paper, you know, it gives a certain impression. Our client was in the throes of custody issues. He understands that he made the wrong decision to take his anger out in that way, rather than, you know, addressing it in a healthy manner. Mr. Carter volunteers as a football coach at a local high school. He is a former NFL player, and he is giving his talents and giving back to the community in that way. He is fully committed to continuing that path. He is fully committed to working on himself, and this incident does not define him. He is remorseful, and he's ready to change under your supervision.
All right, why is there a request for BIPP? I'm sorry, you're not the attorney on this, but I mean, was there, I understand that this is seen as a form of abuse, but isn't BIPP for physical?
Battery? Yes, Judge, and I can just imagine because it's someone who was a spouse of his and someone, this is not just some random person. And so,
I mean, I'm not gonna order that. How old are you?
46.
All right, why are you threatening to send out videos?
I made a mistake.
No, you didn't make a mistake. You made a choice.
I made a choice. I made a bad choice. And didn't think why I did the action.
Like why? And why were you knocking on her door or knocking on her window? What were you expecting?
Talk about my daughter, but it didn't help at all.
Well, what time did you go to talk about your daughter? What time was it?
It was late.
What does late mean?
Past a bedtime, 10 o'clock, I think. Well,
All right, nobody's knocking on somebody's door at 10 p.m. to talk about their daughter or talk about their child. They're usually there for something else. Did you call her? And I see you called her and she blocked you.
yes, ma'am.
All right, so it appears that she doesn't want you anymore. I don't know why people can't accept that. And it's not like you're a teenager. Even teenagers, when somebody doesn't want you anymore, you can move on. As my grandmother would say, cry on the inside. Don't let that person know they've broken your heart and just move on.
Yes, ma'am.
I don't understand why you don't understand that.
if I may, I think context matters here.
Oh,
My understanding is that the complaining witness was withholding visitation from my client. And he had no way to do it. A custody suit has ensued and they're working that out. But during that time, they were breaking up.
so why would he go over her house after 10? Why not go over there at lunchtime? Why not go over there during, daylight time?
I think he was frantic, Your Honor. And he understands, right?
I want to find out if he was frantic. He hasn't told me anything.
I just reacted the wrong way.
No, but I mean, why go to her place at 10? And the reason why I'm asking you these questions, it's so I can determine whether or not all of these extra conditions that the state is asking, whether or not that's appropriate.
Because at the time I was allowed to come over there anytime I was so serious. And I thought we could go over there.
What do you mean you were allowed to come over at any time?
No, because I used to go over there like to see my daughter. I leave to go home by 8 before she go put in bed. And all of a sudden, then she got mad at me and then she blocked me and I was just talking to her and I just went over there and I should have went over there.
Mm-hmm.
That's when the custody thing came up then after the fact.
So what family members do you have in San Antonio?
I moved out here just for my daughter.
To co-parents.
To co-parents.
From Alabama.
Well, we was trying to get together. I bought a house here and we're not together, so I'm stuck in San Antonio. So I said, and I only got here about my daughter here. That's it. I don't have no family.
So how do you all discuss childcare issues? What is happening with that? Is it through the app?
Right now, we've been talking to each other on the phone, and my daughter got a watch, and I've been hanging out with her when she allowed me to see her. Take her to eat. Supposed to be going to see the light show tonight, so that's what I've been contacting.
With the complainant and the daughter.
Right.
So they're amicable.
Within both of us.
Well, here's the thing. People hang out with each other and then they think things are great. And then maybe they'll decide that they're going to get back together. You shouldn't do that because whatever issues y'all had previously, these same issues are there.
Judge, he also has a daughter that's 17 that is in the state championship as a wrestler in Alabama. She's already not committed, but she's been offered a full ride to the Naval Academy. So we'd ask that he be able to travel freely between Alabama and I guess Annapolis, right? Should that be where she commits?
All right. So what I can tell parties, I don't know why people get in relationships and then they have this issue with the children where people are not letting people see each other, not letting people see their children. But this is what I can tell you. When a relationship is over, it's over. Don't try to get back in that relationship. You and the complainant are supposed to be adults and everybody's supposed to be putting their children first.
Yes, ma'am.
And when people hurt the mother of their child, the father of their child, just being petty, then you're hurting the child. Do you understand?
Yes, ma'am, I understand.
And I can tell you, until things were explained to me, I was close to giving you jail time as a condition. But now I'm able to see everything, and the state was not asking for jail time as a condition.
Judge, again, context, complaining witness and my client went to the same school, Troy University, Alabama. And he played football for the school, and she was a athletic trainer, correct?
Yeah, I've been on a lot.
So it's an on and off relationship for 20 some odd years. Is that right? For 6 years.
It's been a while.
Then the baby came along and she had to do the right thing, moved to Texas to co-parent, and things happen.
All righty. This is what the court is going to do. Court is going to sentence you to 2 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. The coaching that you do, are you paid for that?
No, ma'am.
Okay,
I'm
so,
gonna get paid for it.
all right, so there's to be no there's to be no employment as a home health care provider with minors. There's to be 100 hours of community service restitution. Ms. Abrams, if you verify that he's actually coaching, that can count towards his community service hours. Field visits 1 time per month for 3 months. And the complainant is requesting the no harmful or injurious contact.
Yes, Judge, and the idea is for the child custody and transferring.
All right, and there's, yes.
He has total and permanent disability with the NFL, and so he's not allowed to work for that.
He'll need to provide proof of that.
Okay.
All right, so proof of employment within 40 days or proof of inability to work. And the court will require an anger management class. And I'll require a parenting class. Probation, is there anything else? Oh, I'm sorry, I wrote it in, but I didn't say it. No harmful or injurious contact with the complainant. All right. Is there anything else that you need from the court to be successful? All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. If you complete everything early, the court will consider early termination.
And Judge, I may have not on it, but did you allow travel?
Ms. Abrams? He's allowed to travel to events with his other daughter. So he's allowed to travel to out of state. Because maybe they're going to go to another wrestling tournament other than Alabama.
And is that just particular to his daughter, Your Honor, or can it be also, he has an elderly mother because that lives in Alabama, he helps care for, he's the only child that can care for her.
All right, you all will just need to approach on that. Your attorneys will need to turn that over to probation.
Thank you.
Okay.
Thank you.
All right, Vashawn, just go ahead and say he's allowed to travel out of state for his child and also for his mother. And there's to be UA upon return. So that'll be a UA within 24 hours. So if you leave and you come back, it'll be the UA the next business day. And you can either do UAs or either you can do the patch. The patch costs more, but with the patch, probation will just put a patch on you. You don't take it off, don't tamper with it, because that'll be a violation of your probation. They will pull it off and then they'll test it. All right. Did you review the trial court did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Right, because this plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we're off the record. They're saying they have a victim impact. Basically, what ends up happening is the complainant speaks to you. I require that everyone is respectful to each other, and usually the complainant will tell you their feelings on this offense. Do you understand?
Yes, ma'am.
Great, thank you.
Marissa Giovanco for Mr. Garza.
All
Morning.
right, good morning.
Happy belated birthday.
Oh, it's not belated. I celebrate the
Oh,
entire month.
there you go.
And so does the court reporter
I
now.
did already tell her, yes, happy birthday.
All right, so we are here. You filed a motion to modify bond conditions. And counsel, Ms. Pratt is still listed as the attorney. Is she remaining on this case?
No, Judge, we talked about that and you signed the motion to withdraw last time I was here.
Okay, I don't know why it continues to show her.
I don't know.
Could you all look and make sure that she's listed as the attorney on this case, please?
I think I
And I
have
do
been.
recall.
Yeah, I have been on it the whole time, but I was under Miss Pratt's firm originally, and now it's my firm.
Yes. All right, so we are here on a motion to modify bond conditions. Have parties had a chance to confer?
Yes, sir. Yes,
Is
Judge.
there an agreement?
No, Judge.
All right, defense, do you have any witnesses?
Yes, Judge.
Yes.
May I call Simon Garza?
All right, if you could raise your right hand for me, please. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand, state your name for the record.
Simon Alexander Garza.
You may proceed.
Thank you, Judge. Simon, how old are you?
I'm 22.
Okay, and do you have any educational background? Can you tell the judge?
I had graduated medical assisting school as well as a certification with phlebotomy.
Okay, and when did you graduate?
I graduated back in March, I want to say. I had completed my schools
Of 2025?
of 2025.
Okay, and was that prior to this arrest?
Yes, that was prior to this arrest.
Okay, and this arrest that we're here for, you're here on a manslaughter charge. What is it alleged to involve? Is it alleged to involve a traffic accident?
Yes.
Okay, and when is the alleged incident occur?
The alleged incident occurred somewhere in early October of 2023 or 2022.
Okay, so how long after the accident were you arrested?
About 2 years.
Okay, during those 2 years, did you have to report to anyone?
No.
Did you have to go to court at all?
No.
Did you have any monitoring whatsoever?
No.
Okay. Besides this arrest, have you ever been arrested in your entire life?
No.
Okay. Do you drink?
No, I've never drank. I never plan to.
Okay, is that a religious reason for you?
Yes.
Okay, and so alcohol was not a factor in this incident?
Yes. It was not.
Okay.
Yes.
Okay. Are you working right now?
Yes.
Where are you working?
Right now I'm hoping to build the university hospital down in South.
Okay, what do you do helping to build the hospital?
So right now I'm doing work in the yard. I'm hauling copper pipes and moving boxes, filling out orders, receiving orders.
Okay. Is it fair to say that you're not able to find a job in the field that you have a degree in?
Yes.
And why is that?
My case, they when I applied, they like to tell me to come back whenever things are finished and
Okay. And what hours are you working in construction?
So right now I'm working from 7 a.m. to 3 p.m.
Okay. You are currently on partial house arrest with a GPS monitor, correct?
Yes, that's correct.
When did you get that put on?
I got that put on in July.
Of 2025?
Yes.
Okay. Have you had any violations on GPS?
I have had no violations.
Have you had any bond violations whatsoever?
No.
Okay. And have you always shown up to court dates
Yes.
on time?
Yes.
Okay. Do you have family here in San Antonio?
Yes. All is here in San Antonio.
Who all lives here in San Antonio?
My mother, my 5 siblings, my cousins and uncles.
Okay. What about you? Are you seeing anyone?
Yes, I'm currently engaged. She also lives here in San Antonio.
Okay.
All of her family.
Okay. Now, while you've had the GPS monitor on, has it caused you any problems at work?
So I'm not able to wear steel toe boots or required steel toe boots. And I've been, running into things. There are snakes on the property.
Would you say it's a safety hazard that you're not wearing the proper footwear due to the GPS monitor?
I would say that.
Okay. Has it affected your work hours at all?
It has. I'm not able to get overtime. I have to leave slightly early just so that I'm able to make it to my home on time. That I'm not over.
Okay, so what do you mean slightly early? What's your schedule?
So my schedule is from 7 a.m. to 3:30 p.m., but I have to leave at 3 o'clock in order to get home.
So you're not in violation?
Yeah, so that I'm not in violation.
Okay. The alleged victim in this case, do you know his family at all?
I
Do you have any contact with them?
No.
Do you know where they live?
No.
You have no reason to contact them whatsoever?
No.
Okay. You also have a bond condition of no driving, correct?
Yes, that's correct.
Okay. How do you get to work?
My father-in-law drives me.
Okay. And how do you get to court every time you have a court?
I either have my fiance or my mother take me.
So you are not driving in any capacity?
No.
No machinery at work?
No.
The limit on your hours and not being able, having to leave early or not being able to work overtime, is that causing financial burden on you?
That is.
How so? Can you explain it to the judge a little more?
So I'm not able to receive overtime because overtime is usually offered on the day of.
All right, so here's my thing. This is what I don't understand. As a part of his conditions, it's partial GPS for work. So if he's working till 10 p.m., that's fine because it's partial for work. I don't understand this. I can't work at, until 3:30 because I need to be home by 3:30. That's not the court's orders. The court's orders are partial GPS for employment. So if your work schedule is from 7 a.m. to 3:30 p.m., then you're allowed to say from 7 a.m. to 3:30 p.m. So I don't understand why my orders are not being followed.
Sure. Let me ask you this. So how long do you have from leaving work to get home?
I have until close to be about 1 minute.
About an hour. Does it take you longer than that to make the drive?
At 3:30, yes.
And is that due to traffic?
It's due to traffic.
Okay. And then do you have to get prior approval or tell your GPS officer ahead of time what your hours are?
Yes.
And is that why you can't work overtime because you don't find out until the day of?
Yes.
Who is your GPS officer?
I believe it's Alicia Pryor.
Alicia Pryor?
Yes.
Ms. Ferguson,
Yes.
can you see if Alicia Pryor can zoom in? All right, you may continue.
I don't have any other questions, just argument, Judge, and no other witnesses.
All right, any witnesses?
Oh,
Yes.
all right, so Mr. Urza, although you stated that you weren't arrested between the time of the crash and when you were arrested for this offense, you did receive a speeding ticket, is that correct? In those 2 years?
I did.
Okay. And then what type of shoes are you wearing today?
Today I'm wearing dress shoes.
Are they boots or?
They're low cut boots.
Okay. And so what type of work shoes are you saying that you need for work?
I need steel toe boots.
Okay, and so what's the difference between, I mean, other than the steel toe aspect of it, what's the difference between a steel toe boot and what you're wearing for?
The steel toe boots have more cushion and they're a bit higher for more protection of the higher ankle.
Okay, and so you're saying that they're higher, or they go up higher on the ankle than what you're wearing today?
Yes, that's right.
Okay, and have you looked to see if there's anything available where it doesn't come up as high on the ankle?
I have there are things, but they're not as there's so right now I'm wearing not right now, but for work I wear composite toe shoes, but I'm receiving a lot of reprimand, I guess you could say. A lot of people calling me out and saying that I'm not supposed to be wearing those shoes and that they're not the proper foot boots.
But regarding the steel toes, they're saying, regarding steel toe boots, have you looked to see if there are any available that have a lower cut on the ankle?
Yes, I have,
Is there any available?
I have the comments.
You're talking about this one.
Nothing further.
All right, we'll continue this hearing once Ms. Pryor zooms in.
Okay, thank
All
you.
right, thank you. All right, we're back on the record in 2025 CR 004128, State versus Simon Alexander Garza. If I could have parties re-announced for the record, please.
Marissa Giovenco for Mr. Garza.
And you're Mr. Garza?
Yeah, that's right.
All right, we have by Zoom, Officer Pryor. Officer Pryor, could you unmute for me, please? Deputy Laura, is the sound on?
Yes, Judge.
All right, could you say something for me, please?
Good morning, Your Honor.
If you could speak up a little bit.
Oh, yeah. Good morning, Your Honor.
Good morning. All right, so I'm calling you on the case of Simon Alexander Garza. Do you have that pulled up?
Yes, ma'am. Yes, ma'am.
So could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand if you'll state your name for the record.
Alicia Pryor.
All right, so this is going to be slightly different from a question and answer situation. I wanted you to zoom in because there's been testimony about his being allowed to work after hours. And so I'm trying to figure out if there's an issue because sometimes he has to work overtime. And his attorney has stated, and he stated that there is a 30-minute window for him to return home after work, but that sometimes he has to leave early because he won't make that window. So I just wanted my orders to be clear, and if there's some confusion, we could clear it up. So I'm ordering that he's allowed to work. He's on partial GPS. So is there anything that I would need to put in my order? For example, he leaves work at 3 o'clock or 5 o'clock. Sometimes you run into traffic. We have construction all over. Is there going to be an issue, or do I need to put something in the order where you all can just track him and you can see that he didn't make any stops? He's coming straight from work to home, but maybe there's construction, maybe there's traffic, and he's not going to get back home, within the 30 minutes allotment. Is that going to be an issue, or is there something I need to order?
No, ma'am. We give an hour for travel, or he has an hour of travel time. So he's able to get home. He needs to be home by 4:30 p.m. is what I currently have, since he's scheduled to leave work at 3:30.
All right, so they're giving you an hour. Is an hour not enough time for you?
Not the one day that I did try to
I'm sorry, you're gonna have to speak up so she can hear.
so the day that I did try to leave work at 3:30 exactly, I ended up getting home at around 4:20, which is 10 minutes away from that cutoff time, and I didn't want to risk any accidents maybe happening or construction or something.
All right, so this is what I can tell you. Normally what ends up happening with violations on pretrial matters, one, it comes to me. Two, I'm sure, Ms. Pryor, if you see that he's not home at his allotted time, you're able to look and see that he's traveling on his way home, and maybe there's some issue with traffic. I could be wrong, but I don't think they'll be filing a motion for me to review as a violation report if you're 10 minutes late. They will usually, and correct me if I'm wrong, if you're late, they will look at the tracking and they will see. And then it will come to me and say, oh, this person stopped at HEB, this person stopped at a club, but that's when I'll get it. You understand?
Yeah.
Is that correct, Ms. Officer Pryor?
Yes, Your Honor. So we'll call the defendant to see why he was late, if it was due to traffic or if there is an issue with car or whatever may have happened. If there was an unauthorized stop, then we would do a violation.
So they will call you. So just be available for a phone call. So there's not a problem with you working overtime. You just need to let them know that you're working overtime. And if, from what I'm understanding from the witness, is that if you're scheduled to leave at 3:30, but there's overtime work, all you have to do is email or call them and say, I'm still at work. I've gotten overtime, and then they will track you.
May I ask her a question, Judge?
Sure.
Okay, Ms. Pryor, as far as if he were to get a last minute, same day overtime shift, is he able to do that, or is he supposed to be giving you advance notice?
It is supposed to be advance notice, just because I'm personally in the office from the hours of 8 to 5, so I could put his schedule in. The on-call officers wouldn't be aware because they don't have access to my email that he's requesting more time to be at work. So if he's scheduled at that time for 3:30 p.m., he has to be home by 4:30. He wouldn't be able to do that day of overtime.
Okay.
So here's my question. Do you work on weekends?
I currently don't.
All right. So what you do is you send an email to them, and the person who will be submitting the violation report would be you, or would it be the person who's working at the desk?
For me?
Yes.
Sorry. For the violation, can you ask the question again?
All right.
Sorry.
So if for some reason, because you say you're scheduled from 9 to 5, if he works over, would you be, and you're not there, and your email, nobody is able to check your email, would you be the person who would enter the violation report, or would it be the person who's on duty?
No, I would do the violation on return of business day.
All right, so you just send her an email and let you know you're at work. According to GPS, she'll be able to look to see if you were actually at your location or not. But if it's going to be overtime, this is the court's order, because I want people to work. If it's going to be overtime, you need to send them an email saying, I'm still at work. I'm going to be here overtime. She's just told you she would be the person who would enter the violation report, not the person on duty. And I'm making an assumption here, and if the assumption is incorrect, let me know. My understanding is that even if it was somebody who was not your normal officer, they would still call you and say, hey, where are you at? That was a bad sentence. I mean, my English professor would be horrible and upset with me for ending with a preposition. So they will call you and say, where's your location? Why are you not at your designated location? Miss Dixon, I apologize. You taught me better. And so did my mom. So you just need to make sure that you're in contact with them. And if you have an extra shift, just send them an email. You understand? Are you able to do that? All right. So, and just be available for phone calls. So if something happens and you're supposed to be home at 4:30 or whatever it is, she's already stated that they will call you and say why you're not at home. And you can tell them, you can look, I'm stuck in traffic. All right.
And Judge, can I still be heard on argument? Because that's not our only issue.
No, you can still be heard on argument, but is there anything else from Officer Pryor?
No, Judge.
State anything from Officer Pryor?
No, he's been really compliant, Judge. I don't
right.
have anything else to say.
All right. Thank you so much. And thank you for zooming in on such short notice. I appreciate it.
Thank you, Ms. Pryor.
Yes, ma'am. You have a good day.
You too.
Bye-bye.
Yes.
Thank you, Judge. Judge, my argument is that Mr. Garza is a young child. He's a young kid. He's 22. He is not someone who has a criminal history. He is alleged to have committed basically what they're saying is a traffic accident. This isn't someone who killed someone, even in a manslaughter. It wasn't an intentionally, knowingly, any form or fashion. This was a traffic accident allegation. And there's no disputing that with the state.
Okay, so with regards to that, I don't know if there's a dispute about that or not. I don't have any facts.
Well, Judge, I think the legal definition of a manslaughter is a reckless killing, so that's what he's been indicted for. Sure.
So that's all I know is what's in the indictment. I don't know any facts. If people want to call witnesses and place them under cross-examination for the facts of the case, then that can be done.
Yeah, and Judge, Mr. Garza did testify that this was a traffic accident.
Do you want him to be cross-examined over the facts of the case?
No, I mean, no, Judge, we've already passed and that was already done. But he did testify it was a traffic accident. I have not heard anything to dispute that. However, the purpose of GPS is to stop people from hurting other people, to stop people from committing additional crimes, to protect victims. the protection from the community, we want to argue for the state side, is driving. They're concerned about Mr. Garza driving. He testified he is not driving. There is a condition of bond that he not drive. The GPS does not add any additional protections that it is intended for. This is not a case for GPS. He has also been on GPS since July of 2025 with 0 violations, and it is creating a safety hazard for him at work. I believe we've solved the hour issues, and I appreciate that, Judge, but it is additionally causing a safety issue for him at work, and it is unduly burdensome and not necessary in this case.
State.
Good. You believe it's necessary, you heard testimony that in the 2 years that he was not indicted, we put up a speeding ticket. And so I think from the state side, it is necessary to monitor him for the safety of the community. And so we'd ask that we keep it out of the order.
All right, thank you. All right, the motion will be denied.
Thank you, Judge.
Thank you. Anyone else ready?
Yes, Judge, we have, page 9, first one down, Willie Phillips.
So you just have cocaine in your car? So if you were not using it, then what? The mother or child was? Then why was it in the vehicle? Right, well, why is he hugged up like he's not gonna see her after today?
I did not see them.
Okay.
No, so I can't.
I could see it without my glasses.
Yes, ma'am.
All right, the court is calling 2025 CR 013-412 State versus Joe Gilbert Martinez. Can I have parties announced?
Megan Galloway for the state.
Christopher Simkins for the defense.
And are you Mr. Martinez? State, are you proceeding on the indictment as presented?
No, Judge, we are moving to proceed on the lesser included offense of attempted possession of a PG1 less than 1 gram.
Any objection?
No objection, Judge.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense. They're asking that your sentence be assessed at 1 year in the Bexar County Jail. There's a $1,500 fine, no application for deferred adjudication, and the state recommends community supervision. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
It is, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Have there been any such motion?
There have been none, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation, 200 hours of community service restitution, and the DOEP program. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest? After reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
We ask that you follow the plea bargain agreement, Judge.
All right. So who is Brandy Zavala?
My baby.
The mother of your child? And do you all live together? Does your child live with you?
Yes,
And how old is your child?
1.5.
All right. So why are you doing cocaine and you have a child?
It was a stupid mistake.
Well, no, these are not mistakes. These are choices. If you're drug tested today, what is it going to tell me? That's an odd turn of phrase. What will it be?
Just probably like drink. I was drinking last night beer.
Mm-hmm. Why would you do that knowing you have court?
Well, I didn't know I had court. I just got the email. So that's, yeah, no excuse.
Mm-hmm. So how often were you using cocaine? So you just have cocaine in your car? So if you were not using it, then what? The mother or child was? Then why was it in the vehicle?
I made a mistake.
What? Okay, since you want to use the word mistake, what was the mistake?
Of having it in my car, having someone in my car with it.
Mm-hmm. Well, no, according to this, there's an odor of marijuana in the vehicle. Does your child ride in that vehicle? So you have a separate vehicle for your child to ride in, one that does not smell of marijuana. All right. And then there's cocaine in the vehicle. So it says that the other user of this vehicle is Brandy Zavala. So who else are you allowing in the vehicle? Okay, yeah. All right, so one, I don't think you're going to be able to successfully complete probation. So if you want, I'll sentence you to 1 year in the Bexar County Jail. But if you do want probation, I can tell you what's going to end up happening. Probation is going to be coming to your house on a regular basis, checking, because obviously Child Protective Services is not involved in your life and they should be. So how many children are in the household other than this 1-year-old who can't protect themselves and tell their parents, please, you stink, you smell of marijuana?
Just my son. Just my son.
And who else helps you all with the child?
Daycare.
All right. And where do you work?
Barbara.
All right. And does she work?
Yes, ma'am.
What does she do?
Telemarketing.
All right. And does she smoke marijuana? So why would she be with you? All right. This is what the court is going to do. Court is going to sentence you to 1 year in the Bexar County Jail, suspended and probated for 2 years. Do not come for me asking for early removal because it's not going to happen. Regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home healthcare provider or with minors. Probation, I'm going to want random monthly field visits until further notice. And please have someone check on the child.
Yes.
There's going to be 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, parenting classes, once that's completed, 100 hours can be deducted of the community service restitution. I'm going to order the MRT. Once that's completed, the remaining 100 hours will be deemed satisfied. TAP evaluation out of custody. Follow recommendations. And I'm going to want 30 sober support meetings in 30 days. Probation, is there anything else? Yes. Is there anything else you need from the court? All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. Here's the thing. When you bring a child into this world, the child doesn't get a chance to, at least I don't think, the child gets a chance to say, you know what? I don't want those two people to do my parents. They don't have their life together. Give me the parents who have a stable employment, stable housing, not going to be surrounding me with the smell of marijuana. They don't get to choose, right? So you have a child, that child cannot fend for himself, 100% dependent upon you. And I guarantee you that the daycare can smell that your child smells like marijuana. And if they smell that your child smells like marijuana and they haven't called Child Protective Services or anything else, that's not a good daycare center, because that daycare center should be looking out for your child. And when children are that age, their brains are forming.
Yes, ma'am.
So would you give a child a marijuana cigarette to smoke? Well, why not? Right? When you smoke and your vehicle smell like marijuana and your clothes smell like marijuana, you might as well be giving that child a marijuana cigarette to smoke. So you need to get your life together. If you do not, what's going to end up happening is you're looking at being at the Bexar County Jail for a year, right? Or either going to prison because you're possessing drugs. You understand? All right, good luck to you.